Judgment. For judgment, item number 1, CRA 20 of 2000.
The trial court judgment is set aside, the appeal is allowed. The bail bonds of the accused are discharged.
Item number 2, CRLA 145 of 2003.
For three of them, if converted it through 304 part 2, and the others are acquitted of 302. For the remaining offenses, it's confined to the sentence already undergone.
Item number 3, WPC 15349 of 2010.
The interim order is vacated, the writ petition is dismissed. Yeah, the other two are disposed of in terms of the said judgment.
Item number 4, WPC 22305 of 2010.
The writ petition is dismissed, no orders is costs.
What's the request for physical mention? For physical mention, Mr. SD Tripathi.
To mention, my lord, I am seeking review of my lord's order dated 15/11/2021 in
Sitting with whom?
my lord.
Take him up. We have it on a 8th April.
Supplementary list fresh admission, item number 5.
None appears. This was
Supplementary list fresh admission, item number 6.
none appears. This was not.
Item number 7, supplementary list.
No instruction, my.
Concept petitioner states he has no instructions disposed of.
Supplementary list, item number 8.
None appears. This was not.
Supplementary list, item number 9.
May I pardon me, lords. Kindly taken up next to you, lord.
No, we're not
Because
adjourned.
I am ill, my lord.
Sorry?
I am suffering from spinal cord injury, my lord. I could not ready, my lord.
Let's see what the matter is about. It's only a PIL, right? If it's a PIL, let's attend to it immediately. You can sit down, sir. We'll meanwhile look at the papers. Kindly sit down. We'll examine the papers. You do not have even the papers. Very good.
Next to
No. Let us first examine what the matter is, sir. Since it is PIL, it must be something very important, correct? If it is a PIL, it is something very important. Otherwise, you will not file a PIL. So we'll examine it. You kindly take your seat. Annexure 2 is what? Case Pastor General. Merger of the Kionjar sorting with Jajpur. These are not matters for PIL at all, sir. Sorry. The petition seeks to challenge a decision taken in the office of the Chief Postmaster General, Department of Post India, regarding merger of the Kionjar sorting with the Jajpur Road RMS and the Puri RMS with the Khurda Road RMS. Full stop. These are not matters for which a PIL is to be entertained. The court is not satisfied. The court should interfere at all. The petition is accordingly dismissed. Put his appearance.
Supplementary list, item number 10.
Mr. Sahu.
Supplementary item 10.
PA filed by the Advocates Association, All Odisha Advocate tax advocate assistant.
I know. Mr. Sahu is appearing.
Yes, yes.
Are your pleadings complete, sir?
No, my lord, it's coming first time.
First time?
Yes.
Earlier, something else had been filed.
That is on the other issues.
Oh, I see.
As extension has already made as per
Clarification 1 given in circular 99/2021 respect of 234A.
one prayer has already been complied with because he is seeking for an extension of the date of filing of the returns.
That's
That
already
has been-
there.
That has been completed by virtue of this
Oh.
notification dated 1/2020. Second is the glitches, you not that is
Not to charge interest under 234A.
yes, that has to be
Examined, is it?
yes. But so far as first prayer is so far as extension is concerned, this
Mr. T.K.
notification
Saraswati
circular
appears
is
for the
completed.
revenue and advance notice and produces
I'm sorry, we need one copy, sir.
a CBDT circular date, communication date, circular date, 11 January 2022, extending the timelines for filing of income tax returns and various reports of the audit for assessment year 2021-22. In that view of the matter, prayer Roman small 4 is taken care of. Paragraph. As regards other prayers in the petition, counsel for the petitioner is not present. Meanwhile, Mr. Satpathy says he's taking instructions. List on 9th May.
Supplementary list item number 11.
Just, Mr. Satpathy, just point out to that boy behind you. Just come. This is your office matter. This item 10. Are you aware of it?
We need one Passover.
No. So we are just keeping it for 9th. He will show you a copy of the circular. One prayer is taken care of.
Yes, ma'am.
You please tell Mr. Sahu that we're keeping it for 9th.
For 9th, Milats.
9th May. Because he needs to take instructions on the remaining things.
Yes, Milats.
Ah.
Oblation, Milats.
You put his appearance, yeah. You say later Mr. So-and-so appeared and he's been apprised of the order. Right.
Supplementary list item number 11.
Kindly give your name. You know what, in Delhi and all, you keep
Supplementary list item number 11.
Tommy and Mishra must be there.
Lord, supplementary item 11, is it, Lord?
Yes, Mr. Mishra.
I'm so sorry, Lord. I'm so sorry. Lord,
So they want a PHC.
yes, Lord, that is it is not being established for a very long period of time in spite of.
All right. You say the short prayer of the villagers of Mangarajpur Patna, Achyutapur PS, Jankia district, Khurda, is for establishment of a primary health center in their village. So as many as 121 villagers have come together to file this petition. You say notice, Mr. Das accepts notice for opposite parties.
Lord, for all 5.
Yes, Lord.
A direction is issued. The district, what is the chief district medical officer
CDM.
Khurda to undertake a visit to this village positively on or before 11th April 2022, come up with a time schedule for establishing the PHC in the said village in a time-bound manner. It will be open to the CDMO to also visit any of the neighboring villages
5 villages.
in Khurda, neighboring 5 villages in Khurda. No, to visit the CDMO will also visit the neighboring villages in Khurda and assess the need for the PHC and draw up a plan for that as well. the time-bound plans be placed with an affidavit before this court by the next date. List on 25th April 2022.
Obliged.
Supplementary list item number 12.
Also, this is against the Commissioner Municipal Corporation. I humbly pray, my lord, the lordship may see annexure 12 to 14 and annexure 5. But the roadside dangerous tree is not cut yet. Although the DFO has written a letter, annexure 5, that it can be removed immediately. My lord, may I kindly see the photograph I have given. 12 to 14, my lord. The condition of the tree.
For such a small thing, why should
Not a
people come
small
to the
thing,
court?
yes,
not
sir.
small thing we are coming before. my
I know,
lord,
that's what
unless,
I'm
sir.
asking him.
Unless,
Lord,
sir, we are coming.
In fact, he has also represented before the CMC. Lord. This job is done by the CMC. Lord.
Mr. Nayak is right there. Mr. Nayak,
My lord, the only issue that we face, my lord, is that the necessary equipment, the chainsaw and everything is with the opposite pet number 5, the Odisha Disaster Rapid Action Force. They have the expertise as well as the equipment. You have already written to them.
all right.
provision
The
is also
only,
clear.
Mr. Nayak, appearing to the
275
CMC on
one.
advance notice states that the only issue facing them as far as removing the tree which is causing a danger is that the equipment for it is available with the commandant ODRAF opposite party number 5.
May I also, there's an 11 kVA line going there, the electric line, that also needs to be taken care of. So TPCODL, the Tata Power Company, is opposite part number 6.
All right. Further, there is 11 kVA line running in the area which may be affected if the tree were to be cut. The executive engineer, TPCODL, bracket, opposite party number 6, has to cooperate. Full stop. Accordingly, notice is issued to both opposite parties 5 and 6. Can you accept for 5?
Yes, ma'am.
Mr. Das accepts notice for 5. Notice on opposite party number 6 be served Dasti within the next 1 week. Paragraph, both opposite parties 5 and 6 will meet the, which is the officer in your end, superintending engineer, Mr. Nayak.
Executive engineer.
Will meet the executive engineer. We'll have a meeting, joint meeting with the executive engineer, Cuttack Municipal Corporation, bracket CMC, and on or before 11th April 2022, and come up with an action plan for removal of the tree in a time-bound manner within a further period of 10 days thereafter. The action plan be placed on the compliance report be placed before this court on the next date, list on 26th April.
My lord, just I have a small request, my lord. My lord, in this case, my lord, in IA, the petitioner stated that the tree is situated in the private plot, my lord, and the owner of that plot has not been added as our opposite party, my lord.
In this connection, your lordship may kindly see 275 of the Act, section 275. How it has clearly stated how they, even in the private place, notice may not be served upon it and the tree can be cut.
He's going to create problems anyway.
So since the order is being passed in his absence.
So you say the meeting also, the owner of the property in which the tree is presently found may also be involved in the meeting, so
Yes.
that his cooperation is enlisted. Right. List on 26th April.
Okay, obliged.
Supplementary list item number 13.
May I please your lordship? Lordship, section 148 notice approval from learned JCIT instead of Commission of Information.
Where is Satpati or Mohapatra? It's covered. All right. JCIT, the same JCIT order. The notice is quashed. All right.
Deeply.
Supplementary list for orders item number 14.
None appears dismissed from office.
Supplementary list item number 15.
None appears dismissed from office.
Supplementary list item number 16.
Not present.
Not pressed. All right.
Item
Also very senior plot.
Illegal lifting of sand by blocking the flow of water in river Mahanadi.
You're Mr. Praharaj.
Minus.
Sir, you have to get a new gown, sir.
Sorry, minus.
Sorry.
Sorry.
It's all right. It's all right. What is it? Sand Sairat.
This is regarding illegal lifting of sand from river Mahanadi in Cuttack down by blocking the free flow of water and by creating ridges by which the buffaloes, cats, goats have been killed, drowning in the ditches.
Which are the particular instances? Who's doing it? Who is doing it, sir? Have you found out any one person doing it? Sudhakar Naik.
The opposite part number 5 minus.
He's still having does he have a license or he's doing it without license?
He has a license for some other area, but he's lifting in the place where he's not been granted permission on that particular plot minus.
The Tahsildar Tangi had put it at auction, my lord, and the OP5 had taken it on auction.
No. What he's saying is what he took area A for auction,
Yes.
but he's going beyond that area.
But that averment is not there, my lord.
No. The prayer itself is that.
The prayer is, my lord, opposite part number 1 and 4 to stop digging, extracting, lifting, carrying, and transporting sand from Mahanadi riverbed from plot number that is blank and khata number that is blank under Chodar and nearby area.
Why do you have blanks in the prayer clause? No.
Yes.
Here he's filled it up. What he's given you is blank.
My lord,
For the court, he has filled it up as 959 and khata number 329. The allegation is that opposite party number 5, who has been given a Sand Sairat lease for a period of 5 years.
My lord.
For which plot has he been given lease?
It is not, that is one plot.
What is that one plot number? For which plot has been given lease?
959 in khata number 329.
Sir, that is what he's been given. Then what is the problem?
That is the total area 27 acres, my lords, that I have covered in paragraph 3, my lords. Out of that 27 acres, he has been granted for 14 acres that I have covered in paragraph 5, my lords.
So he's going beyond 14 acres.
My lords.
Lordship, kindly see the averment, my lord. Para 5, the Tahsildar Tangi has put an area such an acre 14 acre to auction under OMMC rules as Sand Sairat. Sudhakar Naik, the opposite part number 5, is the highest bidder. Lease has been sanctioned in favor of Sudhakar Naik. All forms, including form number Y, Transit Plus, Challan, etc., has also been granted and issued in his favor by the Tahsildar Tangi. But some unsocial elements and miscreants of the locality clubbed together for illegal gain. So the allegation is with regard to any third party, my lord, not as against the opposite part number 5.
No. Just see the last 4 lines of para 5.
My lord, the land brokers.
No.
My lord.
The contractor who has been undertaken. That's a different contractor.
Para 5, my lord.
Page 4, para 5. Bottom.
The people of the locality represented, my lord.
I don't know. Have you got the same petition or he's giving you a different copy? I don't know.
My lord, same picture, my lord.
How does para 5 begin?
My lord, it begins from the Tahsildar Tangi Chodar.
So
Yes,
the same paragraph, next page, last line says the contractor who has been
undertaking the expansion of NH 55 also has been encouraging the hooligans for supplying the sand in the illegal manner for his
This contractor
illegal.
is which contractor? The sand man or the contractor expanding the highway? Or is it the same man?
No, different person, man.
So what is the allegation against opposite party number 5?
He along with the contractor.
Read from the petition what the allegation against him is. I hope you're not filing it on his behalf.
I have filed it.
Who is doing this illegal mining, sir? What is the allegation? You do not have any allegation against opposite party number 5.
Opposite party number 5 has been granted lease for 14 acres.
What is the allegation against him, sir? Para 6.
The opposite party number 5 is also with the hooligans of the locality.
No, that you have not made that averment. Where have you made that averment? There's no such averment. Against opposite party number 5, where is the averment? Where is the allegation against him?
Let it come next week, man.
So if you want to withdraw and file a proper petition, this is pending since 2019. Council of the petitioner seeks leave to withdraw the present petition and file a proper petition in accordance with law. Dismissed as withdrawn with liberties paid for.
Supplementary list item number 18.
The OA transfer case.
Item 18, my lord, infractions.
Infractions, correct.
Supplementary list item number 19.
None appears. Dismissed.
Supplementary list item number 20.
None appears. Dismissed in office.
Supplementary list item 21.
None appears. Dismissed in office.
Supplementary list item number 22.
None appears. Dismissed in office.
Supplementary list item number 23.
I may please your lordships. Here is the case, milords, where milords the industry, that is milords the Nilachal Ispat Nigam Limited milords. Milords an industry milords capable of producing milords the oxygen plant as well as other milords the.
So something else has happened after you filed this petition?
Yes. As I understand, my lord, on 31/1/2022, the government has approved the sale of
so it's already gone past.
Tata Steel long products.
You have to make them parties now.
There is an identical case, so lordship. WPC number 20529.
When is it coming up?
Lord, 10th May.
List on 10th May, by which date the defects will be removed. All right. 10th May along with writ petition.
Along with WPC 20529 of 2021.
20529 of 2021. All right.
Supplementary list item 24.
May I please also? Well, in this repeats, I am challenging the virus of some provisions of Orissa Gram Panchayat Act and Orissa Jilla Parishad Act.
There are defects, sir. Who's filing it?
My lord.
Who are these petitioners? 7 petitioners.
They are the residents of district Moirabhanj. Moirabhanj is a totally scheduled area, fully scheduled area. And I'm taking a lordship to the para 4, my lord, of my writ petition. Because on the 73rd amendment, part 9 of the constitution that has inserted the one part that is the panchayats.
All right. We'll just say notice subject to removal of defects. Notice be issued. Whom are you appearing for, Mr. Das?
My lord, I'm appearing for only 2.
OP number 2, we are the OP number 1, my lord.
Mr. Pari for OP number 1, Mr. Das for OP number 2. Replies within 8 weeks, rejoined for the next day.
Also, along with Mr. Karthik Jana.
All right. List on 27th July.
Supplementary list item number 25.
Again, already there are so many petitions for this. Are you there? Somebody must be there for the department, I think. There are other petitions already filed. This challenge to the virus of this non-government colleges grant in aid order.
Yes.
They already challenged to this and many other petitions.
Copy has not been solved.
We'll pass it over once.
Supplementary list item number 26.
May I please, your lordship?
148.
Yes, lordship. Notice issued on 1st April 2021 and served on the petitioner, your lordship, on 1st April 2021. Therefore, your lordship, without complying provision of section 148 capital of the act. Similar matter, your lordship, on 11th July 2021.
Notice 11th July, no coercive steps. All right.
Lordship, no coercive action.
Supplementary list item 27.
May I please, my lord? My lord, kindly have a glance to running page number 17. A Platinum Jubilee Committee of a government school.
Why are you upset with one statue?
Yes, my lord. Why? Because, my lord, for installation of statue, A rule is there.
Sir, our country is full of statues. What is harm in having one more statue?
My lord, they have flouted the law. That's
What
why
law, sir? What law?
that's why I am before your
There are
lordship.
so many statues. Everywhere you turn, there are statues.
The statue of a British era ruler who had suppressed the freedom movement.
How can we determine all that, sir?
My lord, it is government high school, my lord.
Lord, he has I mean, the person whose statue is now going to be inaugurated, he has donated the land. He was the founder of that school. And when the school management is now trying to construct the statue, the petitioner has
My lord, the Platinum Jubilee Committee, without authorization, had already installed the statute. That's why I am challenging, my lord. The rule is very clear. For any type of infrastructure development, permission to be taken up before the district education officer or director higher secondary education. They have not taken any sanction, my lord. So let them take instruction, whether there is any direction or not.
PIL for everything, Mr. Mohanty. You come for much more serious matters. How come you are coming for this kind of matter?
Rule of law, I am, my lord, relying, my lord.
My lord, in fact, he was also the student of that school.
If you start saying rule of law, you walk around Cuttack, you will come across 10,000 statues which are illegal.
But it is inside a high school, my lord. What message it will send?
I don't know.
Let them take instruction whether they have don't take permission from the appropriate authority or not, my lord.
Mr. Mahapatra, on behalf of school mass education, is there.
I am appealing. I am appealing. Absolutely no merit. There is a prayer to remove the statue from the school. What is the reason? He is the founder person.
He says you did not take permission from the department.
Yes, ma'am.
For installing a statue, you have to take permission, he says, from the director of higher education.
Well, that was there. That was there.
Where? You just show Mr. Mohanty that permission, then he will just withdraw quietly.
Let it be listed on Monday. Let him supply the copy. I will withdraw, my lord. Because on RTI I have sought information, they have not provided me, my lord.
This is why RTI Act is important, sir. If you had supplied this information, you would not have filed this PIL.
My lord, because they are going to unveil it on 22nd April, my lord.
You timed it.
Time part, my lord. Let them show the document. I have nothing to say, my lord.
Yes, Mr. Mahapatra. If the document is there, you please show it.
Yes, your lordship, may adjourn to some other date. I will take instruction.
Mr. Mahapatra appearing on advance notice for opposite party number
1.
States that he will provide copy of the permission granted by the Department of Higher Education.
School and mass
Education for installation of the statue in question in the school. What is the name of the school? 1 minute.
Ramachandra High School.
The Ramachandra High School. Khandapada. In Nayagarh. That is advance copy of the said permission letter be provided to Mr. Mohanty, Learned Counsel of the petitioner, before the next date of hearing. 12th April. Sir.
My lord, 2nd they are going to unveil it, my lord.
2nd April?
2nd April, yes, my lord. So I don't have any objection about other statues, my lord. They are great personalities. I have no second thought, my lord. But
you can't come on 31st and say in 2nd. I thought you said 22nd. I heard you say 22nd. No? I thought you said 22nd.
No, my lord. 2nd, 3rd, and 4th, the program has been fixed, my lord.
Then you share your WhatsApp number with Mr. Mahapatra.
My number is with them, my lord. With the record, my number.
Mr. Mahapatra, have you seen that permission matter or you've not?
Matter may kindly be taken on Monday, my lord.
What is the meaning?
Statue will be on, sir.
There is a limit for filing of cases.
Invite Mr. Mohanty to the unveiling.
I don't want to.
No, what can we do? You've come the last minute. Why did you wait for so long?
No, my lord. On 3rd, it came to my notice. Immediately after doing the research, the petitioner had filed his repentation and IT application, my lord.
See, what normally happens, the statue must already be there. It would simply be covered with a cloth.
Yes.
Without any authority, my lord.
No, what
is my submission, my lord?
Nothing comes up overnight, sir.
Yes.
See, what is this? Is a bronze statue or a stone statue?
It must be a stone statue, my lord. Running page number 18, it is there.
Then you have to have a base, pedestal. It won't come up overnight, sir. You must have watched it coming up. You can't come like this in the last minute.
Because, my lord, fourth also, if they will give instruction, they can also unveil it, my lord. Because the function is 2 seconds, the second, third, and fourth, my lord.
No.
Let them
We
take
can't
instruction.
interfere with those. It's a schedule they've already set up.
Without rule of law, my lord.
What rule of law? You should come earlier then.
That, my lord, I'm showing, my lord.
One statue is not going to
this rule
spoil
is
the
very clear,
education
my
of
lord.
children. No.
Let them take instruction.
No, we're not, no interim order. You just say list on. We'll have it after the function now. List on 11th April. It is made clear there is no interim order.
My lord, the submission of learned government council is recorded, my lord. That already permission is there.
No, I've just said.
So that I will take instruction. I will take
He
instruction.
had submitted that there is permission.
Permission, I will take instruction in that regard.
All right.
Obliged.
Please to post it to
11th April.
obliged, my lord. Obliged.
Right.
Supplementary list item number 28.
My lord, I am in the second item. I am in the second item. The claimant opposite part number 1 is dead, my lord.
All right.
Is to be
Second item,
substituted.
you say counsel the petitioner states that it has become infructuous and is disposed of. You're in the first one, sir.
No, my lord. Excuse me, serial number 22. I am on late, my lord. And
Not like this, sir. When the matter is called out, you should not like this. You are now in item 28. You'll have to wait.
And not press, my
Who is
lord.
in?
Not press, coach, man. 22 serial.
All right. 22 not pressed.
My
Okay.
lord.
28. Who's
Yes,
appearing?
The Raut, my lord. Ranjan Raut appearing. Same claimant, my lord. Same claimant, another doctor has filed it.
All right. This also is infructuous. It's disposed of. All right.
Supplementary list item 29.
My lord, item number 29, my lord. The money meant for slum dwellers has been misled.
You're appearing in person.
No, my lord.
Where is your gown?
Sorry, pass.
We'll pass it over.
Supplementary list item number 30.
Item number 30 on behalf of Escalite. Last occasion, counter file.
Mask. Take off your mask and speak. No, take off. Can't hear you properly. What is it?
My prayer is to take approach step against the doctor and staff who are not regularly attending the Gopon PS New Kamakantia.
What's he saying? Kanakantia. Gopabandhu PHC. So 2014 you filed it and you forgot about the petition. Doctors are not properly attending. You filed in 2014, then forgot about the petition.
Last occasion counter file.
I'm asking you something, you're saying something else.
Five, 6, and 7. None of the doctors are there now. They have all transferred. And
So Mike.
The opposite parties, they are not on rule now. They have all been transferred doctors. And the OP number 7 has expired. And the building, as per my instruction, new building, it has gone to new building. It was
Whom are you for, sir?
I am appearing for 5, 6, and 7.
Oh.
They have all been transferred.
Okay. That
And
that CHC is there or not?
My lord?
He's talking about a CHC, no?
Yes, yes.
That CHC is functioning.
CSC now is functioning new building.
New building.
Yes.
What about new building is empty or doctors are there?
New building is with full staff.
All right.
That is my
So if a cause of action survives, you file a fresh petition. Council appearing for opposite parties 5, 6, and 7 says that the community health center at Mangalpur, PS Pipli, District Puri.
Konta Batia. It is Konta Batia.
Kamakantia.
At Kamakantia PS. This is PHC or CHC?
CHC.
But in Kamakantia, there's only a PHC, sir. CHC is in Astaranga and Mangalpur. Which one are you aggrieved by?
Page number 14. There is a government Kamakanta under CSC Mangalpur.
Under CHC Mangalpur. That Kama Kantia has gone to new building.
New building.
That
That is my
hearing for opposite parties 5, 6, and 7 says that the THC Kama Kantia is now shifted to a new building, and staff, medical officers and staff are regularly attended. Full stop. It will be open to the petitioners, if the cause of action survives, to file a fresh petition according to the law. The petition is disposed of.
My lord, I may pardon that item 28, my lord, that you will also make it infructuous. I want to substitute opposite partner 1, my lord.
My lord, item 28, I could not join, my lord, due to technical problem, my lord. My lord, item 28, my lord, the opposite party number 1 is expired, my lord, in the meantime. We have to take steps for substitution, my lord.
No. What is the prayer, sir?
Prayer, my lord, challenging the award of the passed by the, my lord, permanent continuous Lok Adalat, my lord.
For what?
For awarding negligence.
Compensation for negligence, my lord.
Compensation for negligence, my lord.
No. You people are the claimants or who?
No. We are, my lord, the doctors, my lord.
Doctors, my lord.
What have you been asked to pay, sir?
My lord, we have been asked to pay, my lord, 30,000 compensation, my lord.
Sir, please, this is all. For this, we don't want to entertain my petitions. 30,000 you can't pay.
My lord, because we are not.
The amount is negligible, sir. The amount is negligible. These are all very poor people. You now drag their LRs. What are they supposed to do? Give you back? You got to stay from us, is it?
My lord.
Yes, my lord. Yes, my lord.
Look at this.
My lord, in second case,
You
my lord,
already
I have the
deposited
loss
20,000 in the first matter, and second matter, how much have you deposited?
My lord, in second matter, I have been awarded 10,000 because I am a
What is this, Mr. Manti? For
there is no
10,000,
negligence on my part, my lord. Post-treatment,
No, that's all right. 10,000, 20,000 is no amount at
that
all.
will be a punishment, just like a
Mr.
punishment.
Mr. Manti, the amount these doctors will be spending on this litigation is far more. Let us get real now.
That is correct. My lord.
What is the point? These are all poor people.
That will,
What is 10,000, 20,000, sir?
That will have a bad reputation on the.
No.
I have on my part. I have no negligence at all, my lord.
Are you both not continuing your practice? You are, no? It has not affected your practice. Has it affected your practice?
No, my lord.
Then why should we keep
because of, my lord, once it has a larger implication in the society, my lord.
All that is fine. I'm sure your practice has grown in all these years. It's 8 years or 9 years since the petition was filed.
Yes.
Nothing has happened to all this, sir. These are all very minor matters. You see, in both these matters, the challenge is to the decision of the permanent Lok Adalat (PUS) directing compensation to be paid by the petitioner doctors to the opposite party number 1 complainant. Stop. In the first case, the compensation amount was rupees 30,000. In the second case, the compensation amount is as less as rupees 10,000. In both matters, which were filed way back in 2013 and 2012 respectively, interim orders were passed by this court. Full stop. In writ petition civil 2705 of 2013, the interim order dated 20th February 2013 was to the effect that, subject to the petitioner depositing rupees 20,000 in the name of the registrar judicial, there shall be stay of the operation of the award dated 30th November 2012 of the PLA PUS. In writ petition 25354 of 2012, by the interim order dated 8 January 2013, the order dated 10th March 2013, 12 months, no, the order dated
8th January, 2013.
30th November 2012 of the PLA PUS was stayed. Stop. Paragraph. The court is today informed that the opposite party number 1 complainant has expired in the meanwhile. A prayer is made by counsel appearing for petitioners in both cases that he should be substituted by his legal representatives (LRs). Paragraph. The court is of the considered view that there is no need for the LRs of opposite party number 1 to be brought on record, as the amount awarded is insubstantial. To stop, the concern expressed is about the implications that such an award may have for the professional careers of the two doctors. To stop, clearly, the impugned orders have not had such an impact as is evident from the submissions made by counsel and petitioners. To stop. By pleading the LRs, one would only be prolonging the litigation unnecessarily. And it is a litigation that opposite party number one's LRs cannot afford. Full stop. Consequently, while clarifying that the impugned awards will not be cited as precedents, the court declines to interfere with the awards. The amount already deposited in the name of the Registrar Judicial be now released to the LRs of opposite party number one by the registry by sending an intimation to those said LRs to come and collect the amount. Full stop. The interim order in both petitions is vacated. The petitions are disposed of in the above terms. Right.
Supplementary list item number 31.
My lord, I may be pardoned, my lord. I may be pardoned to make a mention, my lord. Item number 8, my lord. Of your lordship, I could not join, my lord. Only my presence may be recorded. I am for the opposite party.
All right. All right.
Obliged, my lord. Obliged.
Item 31.
It might have influxuous, my lord. My lord, is a case of 2014 public litigation.
All right.
Yesterday night, my office informed that I have filed this petition. I could not believe it. This morning only I have been informed. This is regarding that tribunal rule which came into force by amendment that in order to be the president of the
all that is infractious.
That you must be 7 years. The judge must be having 7 years experience.
Correct.
How it is infractious, I don't know, Mr. All that I know that the cases all over India were filed and were transferred to the Supreme Court.
I see.
So how it has become infructuous, I don't know. And they have filed counter also.
No.
Let him take instruction whether it has been transferred to the Supreme Court.
Madhya Pradesh also, that was filed. Some order has been passed. Thereafter, matter has been brought to the Supreme Court, and retired judges of the Supreme Court taken care of all these things, and they are proceeding for appointing the ITT. So in
Whether
that,
any order has been passed, judicial order has been passed by the apex court, that this court may be informed. After the transfer, I know it has been transferred because you have filed counter also in this case.
Yes, we filed the counter.
Yes.
No, what was the challenge on the ground?
Challenge, Lordship will kindly see.
What is the outcome of the Supreme Court then?
No. Meanwhile, ITAT, I think, has been presided over only by a retired
chairperson
is always now a retired judge.
Is now a retired judge.
What is the problem with that?
Problem, I don't say there any problem. They say that it must be having 7 years experience.
Everybody will have more than 7 years, sir. Any
But
retired High Court judge will have more than 7 years.
7 years, my lord, so far as a central excise tribunal is concerned, is only a High Court judge. They mention. I have given example. Cyber appellate tribunal, only judge, High Court judge. A judge of the High Court is a judge.
Why not 7? What is harm in 7 years?
Then I have no. There is no harm. There is no harm. But suppose a person judge who was discharged his office for 1 year, will he be diseligible for being appointed as a chairperson?
Some qualification has to be there, sir.
Qualification
See, tax is a very niche area.
Well,
Tax is a niche area. You know best. How many years of practice before you get a grip on all these nuances? You say the challenge in the present petition is to...
Lordship may kindly say not pressed.
All right.
Because
counsel the petitioner states that he does not wish to press the present petition. Disposed of is not pressed. All right.
There is noted.
All right.
Supplementary list item number 32.
32, my lord. I'm appearing for the petitioner, my lord. In the meantime, the OP1 filed counter, my lord. And the copy not serve. Direct me, my lord, to serve copy, my lord.
What is the
These
matter
are
about
environmental issues. He has to approach the NGT.
These for the issues raised.
That question raised in the earlier date, my
The
lord.
cause of action still survives to be open to the petitioners to approach the National Green Tribunal in accordance with law. The petition is disposed of.
I am appealing for opinion.
All right.
Directly serve the copy, my lord. At least all the
No.
to know the answer or the reply of the
It's all right,
filed.
sir. It's all right.
Supplementary list item number 33. Item number 33.
None appears. Dismissed. No.
Supplementary list item number 34.
May I please?
Yes.
So this is my lord, a matter under Orissa Anti-Tax Act. And for this period, for this petitioner, your lordship have already rendered judgment under the VAT Act, my lords. The issue involved is without.
I think they've got the spelling wrong in our office, in our registry. In our registry, they got the spelling wrong. It is resins. They've typed it as resigns.
My God. Resins, right?
Right. They added a G. It became resign.
My God.
Yes.
So the issue involved, so without completing assessment, there cannot be reassessment. That is the essence of the judgment which your lordship have referred to in the other judgment your lordship have rendered on the VAT Act.
Right.
What has happened in this case? VAT Act, the counter affidavit, in the reply, they have referred to one judgment of our High Court, Nilachal Ispat's case, where this Honorable Court has said that there may be self-assessment, but self-assessment acceptance is not to be communicated. But your lordship said, whether there is acceptance or not, how can an assessee know? There must be some form of communication or acknowledgement, so that only one will be able to know that assessment procedure is coming. Assessment is a matter of determination of final liability loss, or liability to pay tax.
Right.
Therefore, your lordship, I draw your lordship's attention to that. I have given, I think, copy of the judgment passed in the case of this petitioner, under the VAT Act. Your lordship, may kindly see your lordship judgment dated 1/12/2021, and your lordship only in terms of case of otherwise, your lordship have been briefly disposed of this. It is there. I have given, I think, a copy of the judgment to your lordship. In view of the judgment passed today in STRB 64 of 2016, in case of automobile versus State of Orissa, the present dispensation allowed, consequently improved order of possession cost. And in the case of automobiles case, Millards, I will refer to your lordship with relevant provision. Before that, just I am referring to judgment your lordship have passed. Whereas para 17, because in para 7 of the counter, they have referred to Millards Nilachal Ispat's case, saying that self-assessment, when made, it is not to be communicated and you don't have right to claim for any acceptance by way of communication. Para 17, perusal decision of this court, your lordship got it para 17 minutes. Perusal decision of this court in Nilachal Ispat Nigam Limited Supra reveals that it was in the context of Orissa Anti-Tax Act. Secondly, this court had no occasion in the said decision to discuss the effect of more or less similar amendments affected to the provisions of the OET Act. But this should be obvious. That is little printing typographical, which are brought into effect from 1/10/2015. The amendment was on the OVAT Act. But this is dispute. This is despite of the.
But no occasion, your lordship, no occasion in the said discussion. You obey it, your lordship. That I'll mention, your lordship.
No, there is some.
I'll mention later.
That is despite the fact that the decision is dated 7/12/2016. The amendment did bring about significant change to the OET Act and therefore had direct bearing on the issues discussed in the said decision. Consequently, this court finds that the decision in Nilachal Ispat Nigam Limited in per inquirium, in as much as it fails to discuss the amended provisions of OET Act, which have a direct bearing on the issues adjudicated of this court.
Your lordship, in this paragraph, all the OET Act have to be treated as OVAT because there is no amendment under OET Act.
Yes.
That is the difference in between both the acts.
That's the only. Anyway, now your lordship can turn to paragraph 22 minutes. From the above discussion, the picture that emerges is that if the self-assessment under section 39 of the OVAT Act for the tax period prior to 1 October 2015 are not accepted either by a formal communication or an acknowledgement by the department, then such assessment cannot be sought to be reopened under section 43(1) of the OVA Act and further subject to fulfillment of other requirements of that provision as it stood prior to 1/10/2015. I will just refresh your lordship's memory minutes. Under the OVA Act, what has happened prior to 1/10/2015, the provision for reassessment under the VAT Act was, unless assessment under section 39, 40, 42, 44 not complete, you cannot invoke provision of reassessment under 43(1).
Correct.
And this position stood altered by amendment after 1/10/2015, where this requirement not to be complied with. Because these are matters pertaining to conditions for opening reassessment. Now the fact and the provisions for which your lordship is concerned this petition is, now self-assessment. There is a provision of self-assessment under the VAT Act, so also under the provisions of the OET Act. These are perimetria. And the rules which are framed under the OVA Act pertaining to self-assessment, that is Rule 48. And the provision for self-assessment is 39 under the VAT Act, is perimeter to Section 9 of the OET Act and Rule 15 of the OET rules. Whereas your lordship, I will take your lordship attention to Section 9. Section 9 of the OET Act. Entry Tax Act.
Right.
Subject to provisions of subsection 2, the amount of tax due from a registered dealer or a dealer liable to be registered under this act shall be assessed in the manner hereinafter provided for each tax period or periods during which the dealer is so liable. If a registered dealer furnishes the return in respect of any tax period within the prescribed time and the return so furnished is found to be in order, it shall be accepted as self-assessed, subject to adjustment of any arithmetical or error apparent on the face of the record. Now, Rule 15, my lords, may kindly proceed, lords. Self-assessment. Rule 15 says, lords.
What? Self-assessment. Yes.
Rule 15, yes. Files return for a tax period within the period specifically in subrule 1 of Rule 10, and the return is found to be correctly and completely filled in, and there is no arithmetical mistake apparent on the face of such return, the said return shall be accepted as self-assessed. 2. Where there is any arithmetical mistake apparent on the face of such return, and such mistake can be reconciled.
So then there's an intimation.
Yes, without any reference to dealer to whom such return relates, such return may accordingly be rectified, and the rectification so made may be intimated to the dealer in Form E28 for information. 3. If the rectification is intimated to dealer under subrule 2 is not accepted by dealer, he may within 7 days from the date of receipt of such intimation file an application stating therein the correct position along with reasons for occurrence of such mistake to assessing authority, and if such authority is satisfied, the return referred to in subrule 2 shall be accepted as self-assessed.
So there's no requirement for intimation. If it is
No,
not
yes.
in order.
No, if it is in order, not to be intimated, but acceptance must be a matter of record. Yes, sir. Similar to tender where it is stated no assignment, no reason to assign, but the existence of reason must be there. It may not be communicated, but on demand or subject to judicial scrutiny, whenever your lordship would like to know whether it is accepted in terms of the provision, then the revenue must be in a position to show that it is accepted. But similar pattern is also followed in Income Tax Act 143(1) minutes. They write they put a stamp minutes assessed under section 143 on a total income of so and so for the assessment of so and so assessing officer.
Correct.
They sign it.
Correct.
But if such an endorsement acceptance is there by the revenue, in order to ensure that the procedure provided under 15 read with section 9 are complete, then Miller certainly I cannot
Go for
demand
reopening. Yeah.
So Millers, my humble submission is, without doing that, Millers, without accepting the return in terms of the procedure under 15 and section 9, now they have Millers initiated procedure under section 10 Millers. And your lordship here in case of automobiles have clearly laid down the principle in para 22 keeping in mind the very same perimeter provision of section 39 self-assessment and rule 48. Your lordship have said, yes, may I read 39 and rule 48? Of course, similarly couched.
Right.
Section 39 read with rule 48.
Right.
May I place 39 minutes? Right.
Yes.
You lordship may kindly see the provision. Yes, one. So self-assessment. Subject to provisions of subsection 2, the amount of tax due from a registered dealer or a dealer liable to be registered on the Act shall be assessed in the manner hereinafter provided for each tax period or tax during which the dealer is so liable. Your lordship may skip subsection 2 because subsection 2 prior to amendment is there at the bottom.
Correct.
Yes, if a registered dealer furnishes the return in respect of any tax period within the prescribed time and the return so furnished is found to be in order, it shall be accepted as self-assessed subject to adjustment of any arithmetical error apparent. Similar language. There is no even comma full stop minutes bearing. Now my lords may kindly rule 48 minutes. Just for a moment. Rule 48, your lordship may kindly see the down because rule 48 has been omitted now.
Right.
Yes. Self-assessment where a dealer files return for a tax period within the period specified in rule 34 and the return is found to be correctly and completely filled in and there is no arithmetical mistake apparent on the face of the return, the said return shall be accepted as self-assessed. Where any arithmetical mistake apparent, similar to various other provisions, I will not burden you lordship. The provision which are there, because that is forms are different. So here also very similar manner. I need not. I think proceed further. Yes, same provision. And taking into account all these procedures, my lords, your lordship in para 22 said that from the above discussion,
yes,
the picture that emerges is that if the self-assessment under section 39 of the OVA Act and tax period prior to 1/10/2015 are not accepted either by a formal communication or an acknowledgement by the department, then such assessment cannot be sought to be reopened under section 43(1) of the OVA Act and further subject to fulfillment of the requirements of that provision as it stood prior to 1/10/2015. The lordship was concerned prior to. Subsequent, no such. So therefore, my humble submission before lordship is that in view of the...
You have to extend the same principle.
See, that is exactly, that is what I... Same principle to
Your
follow
lordship, your lordship, may I please your lordship? Your lordship, that judgment as well as those facts may not be considered in this case. Why, your lordship? Your lordship, in this case, as well as in the cases under Value-Added Tax Act, the ratio of challenge is that without making any assessment, reassessment cannot be done. Now, your lordship may kindly look into the identical provision in the provision of section 43 as well as the provision of section 10 of the Orissa tax.
Right.
Now, your lordship, I may be permitted to place section 43 because so far as the acceptance or not acceptance, it will later on. I'll argue on that point.
Right.
Your lordship may kindly turn to section 43 for a moment, your lordship.
Right.
And the pre-amended provision. Your lordship may kindly pre-amended provision.
Yeah, it's at the bottom, correct. Yes.
Your lordship, section 43(1).
Yes.
Pre-amended provision just below to the provision, your lordship.
Yes.
Where after a dealer is assessed under section 39, 40, 42 or 44 for any tax period, the assessing authority on basis of any information in his possession is of the opinion so and so. Your lordship may kindly pause here. Your lordship may kindly look into section 10 of the Orissa Anti-Tax Act. That restriction is not there under section 10 of the Orissa Anti-Tax Act, your lordship. Where for any reason, your lordship, section 10(1), where for any reason all or any of the scheduled goods brought by a dealer has escaped assessment of tax, or where value of all or any of the scheduled good has been under-assessed, or any deduction has been allowed wrongly, the assessing authority on basis of information in its possession may, within a period of 7 years from end of the year to which the tax period relates, serve a notice on the dealer so and so, your lordship. So that restriction that after completion of the assessment under section 39, that is self-assessment, 40, 42, 44, only the assessment can be done under section 43. That restriction is not here. Now, your lordship, so far as your lordship might have remembered, your lordship might have recollect, your lordship, section 39, why your lordship has passed this judgment? By interpreting only the amendment of deemed assessment with effect from 1/10/2015 of 39 to your lordship. Your lordship may kindly for a moment look into section 39, subsection 2.
Of the OVAT Act.
Your lordship, from the beginning, my argument was in that case also that section 7, section 9, section 10, if analogous can be reading, then there it is to be deemed assessment. And your lordship, under VAT Act, I have argued that section 37, section 39, section 42, section 43, if analogous will be reading, then your lordship, it is deemed assessment.
Deemed assessment came on 1/10/15. Sorry.
And since the amendment has been made with effect from 1/10/2015, your lordship has interpreted that. If that interpretation was prior to that, then what is the necessity of that amendment? Your lordship may kindly recollect about the hearing of that VAT Act, your lordship. Section 39(2). If a registered dealer furnishes the return in respect of any tax period, it shall be deemed to be self-assessed.
With effect of 1/10/15. Sorry.
Yes, I'm going to that. I'm going to that. So this amendment has been with effect from 1/10/2015. For that reason, my entire argument under VAT Act, your lordship has interpreted otherwise, and your lordship has interpreted that since this has been amended, so the deeming provision cannot be interpreted prior to 1/10/2015. For that reason, your lordship, the honorable court has decided in Nirachal Ispat case, which is a good law. Your lordship may kindly turn to that portion in that Nirachal Ispat case, your lordship. Because entirely it is different from Orissa Value Added Tax Act, your lordship. Your lordship may kindly look into the paragraph 12. Your lordship, I have given the flag.
I think my friend is detracting the focus.
No.
It is the
reassessment.
I will reply.
I'm
Okay.
So your lordship, my paragraph 12. So far as the ground taken by the petitioner that the company was assessed, as per the provision of section 9(1), as such, it is not known to them as to whether assessment has been finalized or not. In other words, whether the authorities have accepted the self-assessment made by the petitioner company under section 9(1) has been accepted or not is concerned. We are of the considered view that section 9 contains a provision of self-assessment which requires the dealer to be assessed in the manner provided for each tax period and periods during which the dealer is so liable. And if the registered dealer furnishes the return in respect of any tax period within prescribed time and the return so furnished is found to be in order, it shall be accepted as self-assessed, subject to adjustment of any arithmetical error apparent on the face of said return. Section 10 of the Act provides for reassessment in certain cases within the authorities of the reason to believe that the dealer has escaped assessment of tax, and such communication regarding acceptance of assessment made under the provision of Section 9 of the Act is not required to be communicated to the petitioner, and the communication can only go in a situation when on scrutiny it will be found that same is not in order.
See, I think your stronger point is what you made first, that in the impari materia provision in the OET Act, there is no condition that only after assessment is completed in the earlier provisions can there be a reopening. I think that's a stronger point for you. Because here the word accepted is there. In 9(2) of the OET Act, the word accepted is there. So if you go by the accepted word, because we have interpreted accepted meaning some actual act of acceptance. So in the OET Act from 2005 onwards itself, the word accept is used in 9(2). You see 9(2) of the OET Act.
Your Lordship.
If a dealer furnishes the return in respect of any tax period, it shall be accepted as self-assessed. The OET Act itself uses the word accepted.
Accepted, Your Lordship.
So the word accepted was there in the OVAT Act also.
Your Lordship.
Yeah. So I'm just saying we interpreted accepted meaning some actual action of act of acceptance.
my lord, I am on the point that reassessment cannot be done.
No, so that's a different point. I'm
Your
just
Lordship.
saying. So
because the enter challenge here is the reassessment order.
No. So here, I think your strong point is stemming from section 10 itself.
Your Lordship.
10 does not, the 10 as it stood prior to.
All along, there is no amendment, Your Lordship.
Everywhere. Either old or the new 10
Your Lordship.
does not have an opening thing saying after completion of
No,
it.
Your Lordship.
So that is the only strong point.
Your Lordship.
So
for that reason, it is different because so far as the acceptance or not acceptance, Your Lordship, whether there is any arithmetical error, but the whole point here is that under VAT Act as well as Income Tax Act, that after assessment.
Right.
So here that restriction is not there, Your Lordship.
Yes.
Even minor section
And
10.
so far as that acceptance, Your Lordship,
let's not go there because we have taken a certain view.
Your Lordship. And Your Lordship, but that isn't the judgment.
So you are saying this Neelachal Ispat, which is under the OET Act itself, will apply.
Your Lordship.
So for OVAT, it must have been per incurium, but not for OET.
Your Lordship.
Yes, section 10. If your Lordship will look into the words, for any reason, all or any of the settled goods brought by dealer has escaped assessment of tax, or where value of or any of the settled goods has been under assessed, or any deduction. I am not on that. There are two things. There must be assessment of tax, or there must be assessed so that it might have been under assessed. So, this presupposes there must be assessment. But section 10 always presupposes.
But self-assessment is assessment, sir.
Exactly. That's right, Millers. So self-assessment, because under VAT Act, Millers, there are 4-5 different assessments.
Correct.
And 43 says you must have to either 39, 40, 42,
Correct.
44.
Correct.
Here it doesn't say in that language,
Yes.
but it says that there must be assessment of tax or it must be assessed so that if in case of under assessment, you can invoke section 10 Millers.
Correct.
If it is escaped assessment or if it is under assessed. So that presupposes there must be assessment first. So let's kindly see language. A dealer has escaped assessment of tax. 2, where value of or any of the settled goods has been under assessed. So there must be assessment giving rise to under assessment. There must be assessment which might be giving leading to escaped assessment. That is why your Lordship Lords have very carefully referred to many judgments. One full bench judge, your Lordship kindly see that Nilachal is that Keshav Automobiles case. My Lords have referred to Joyশ্রী Chemicals case, where your Lordship have at paragraph 20 minutes. Paragraph 20 Keshav Automobiles minutes. Paragraph 20. Apart from that, the concept of escaped assessment under section 43, here is also escaped of the Orissa value-added tax comes into play only when the assessment has been made and completed. In the instant case, without assessment being complete, the notice of escaped assessment is misconceived. As such, notice is liable to be quashed.
That is also 43.
Just a minute. Now, paragraph 19, 1-9. A full bench, judgment of Supreme Court, your Lordship have followed. To the same effect, para 19 Millers, the decision in Ghanshyam Das Supra, it was observed by the Supreme Court as under one paragraph only I am placing Millers. If a return was duly made, the assessment could be made at any time unless the statute prescribes a time limit. This can only be for the reason that the proceeding duly initiated in time will be pending and can therefore be completed without time limit. A proceeding is said to be pending as soon as it is commenced until it is concluded. On the said analogy, the assessment proceeding made under the Sales Tax Act must be held to be pending from the time the said proceedings are initiated until they are terminated by a final order of assessment. Before the final order of assessment, it could not be said that the entire turnover or a part thereof of a dealer has escaped assessment.
The only thing is
yes.
On the word accepted. Then we come back to accepted.
Correct.
Then we come to para 22.
Para 22 minus.
So the logic, I think in our decision, Keshav Automobiles was this. For finding out whether the assessment was accepted or not, you need a formal communication. Because of the amendment post 2015, it becomes clear that what was there before 2015 required a formal acceptance. It's only after 2015 that formal acceptance was done away with.
Yes, done away with.
But if you look into the OET Act, strangely, right from the beginning, it used the word acceptance.
Acceptance.
So there, a coordinate bench at interpreting the OET Act itself says there no need for a formal acceptance.
Communication.
Because unlike in the OVAT Act, where the amendment brought about the requirement, in the OET Act, there's no such amendment. And the word accepted was used even before. And that is interpreted by a division bench saying no need for a formal communication. So either we refer this to a larger bench for OET Act purposes, because this is by a coordinate bench.
OET Act, because VAT is very clear.
VAT is very clear. I'm now only on OET Act because this present case is under the OET Act. This Nilachal Ispat is OET Act.
Also OET Act.
Yes. So we have to refer this to a larger bench now. For OVAT Act, we could have said it's per inferium because it was not dealing with OVAT Act at all.
Whether this Nilachal paragraph,
that particular paragraph, it says para 12.
Para 12.
Which says such a communication can go only in a situation when on scrutiny to be found that the same is not in order.
Correct. Whether para 12 can be consistent with section 9 read with rule 15.
That's something that we have to refer to a larger bench.
Your Lordship, please. But here,
no, the word acceptance still means that
how can he know? Yes.
How will he know? How can he presume that an acceptance, that assessment is complete without that being an acceptance?
Now that your Lordship have already rendered conclusion para 22, will that again?
No, coordinate bench. See, that coordinate bench for OVAT Act is fine. In fact, you need to file an application for those correction of that para 22.
Yes.
Not para 19, is it?
Para 20, you let's see, all the entities.
Para 17.
70.
Sorry, sir, 70. Your Lordship, all the entities act, your Lordship, I think I could not argue that there was no amendment under OET Act. I have argued, but some miscommunication may be there. So
because the second line, amendments affected the provisions of the OVAT Act.
Your Lordship.
So I think we'll have to file an application for that.
File an application of correction of error.
Para 17 only.
Para 17 only, yes.
Your Lordship. So far as your Lordship has decided that it is por incurium. So far as it may be por incurium.
For the OVAT Act.
OVAT Act.
Not for the OET
Not
Act.
to the OET.
That's why we have to refer this to a larger bench.
May I give a memo for correction? I think
yes.
Memo only.
And that bench will have to correct it. I'm sitting with Justice Rautri.
Yes. Your Lordship, what I pray, my humble prayer, your Lordship, let the petitioner file appeal. So far as the factual aspect is concerned, let the petitioner file appeal. And so far as the legal
this doesn't
issue.
survive, why I will go there? If this doesn't survive, you have to
all right. The short point involved in the present case is whether the impugned order of reassessment for the period
for the period 1/4/2008 to 31/3/2014.
1/4/2008 to 31/3/2014 is valid in view of the non-communication of the original return filed by the SSC. By way of self-assessment under section 9 of the Orissa Entry Tax Act 1999 (OET Act). Paragraph, the contention of Mr. Sahul and senior counsel for the petitioner, based on the judgment of this court in Keshav Automobiles, the state of Orissa, bracket. I think it must be reported by now, no? Bracket, judgment dated 1st December 2021 in STREV 64 of 2016, bracket, is that unless such acceptance of the return filed by way of self-assessment is actually communicated to the SSC, there can be no reopening of the assessment subsequently under section 10 of the OET Act. Paragraph. Counsel for the revenue for the department, Mr. Sunil Mishra and counsel for the department on the other hand, refers to the decision dated 7th December 2016 of a coordinate division bench of this court in writ petition civil 22343 of 2015 bracket Messrs. Neelachal Ispat Nigam Limited versus State of Orissa bracket which arose under the OET Act and wherein para 12 it has been concluded that for the purposes of section 10 of the OET Act there need not be a formal communication of the acceptance of the original return filed by way of self-assessment under section 9 bracket 1 of the OET Act. It will be noticed here that the decision in Keshav Automobiles arose under the Orissa Value Added Tax Act 2004 bracket OVAT Act and the effect of the amendment to the OVAT Act with effect from 1st October 2015 by way of the OVAT bracket Amendment Act 2015. Full stop. It will be noted here that the said issue may not arise as far as the OET Act is concerned, as the amendment, there was no corresponding amendment to the OET Act in 2015. Full stop. Also, the wording of section 10 of the OET Act, which pertains to reopening of assessment, is not in pari materia with section 43 of the OVAT Act, which pertains to reopening of assessment. Full stop. Likewise, the corresponding rule 15 of the OET rules 1999 are not in pari materia with
the rule is pari materia. Rule 15 and rule 48 are pari materia.
In pari materia?
My lord. Rule 15 and rule 48 pari materia. Self-assessment procedure is pari materia.
Then you take out the last line. Okay. The court is therefore of a considered view that the correctness of the view taken in para 12 of the coordinate bench of two learned judges in Neelachal Ispat Nigam Limited, interpreting section 9 bracket 1 read with section 10 of the OET Act will require reconsideration. Good stop. Accordingly, the present petition is directed to be placed before a full bench, a larger bench of 3 judges.
Your Lordship will formulate referral question.
To consider the following question: is the view taken by the division bench of this court in Neelachal Ispat Limited versus State of Orissa, bracket decision dated 7/12/2016 in writ petition civil 22343 of 2015, require reconsideration with reference to the view expressed in para 12 of the said judgment on whether there requires to be a formal communication of the acceptance of the return filed by way of self-assessment under section 9 bracket 1 of the OET Act read with section 10 bracket 1 thereof.
Your Lordship, I'm sorry. Your Lordship, a question came to my mind. Your Lordship, for clarity, Your Lordship. So for section 9, Your Lordship, for admitting for a moment, Your Lordship, acceptance is required, Your Lordship. But here, Your Lordship, the challenge is all around so far as the reassessment order, Your Lordship.
See, that principle that there can be a reopening of an assessment only if there is an assessment,
Your Lordship,
that remains in principle.
Your Lordship.
Always a reopening has to be preceded by an assessment. Only then we call it reopening.
Your Lordship, for that reason, I have my humble prayer is that let him file appeal because he has challenged the reassessment. So reassessment only after assessment.
He says they cannot. He's raising a jurisdictional issue. He says because of Keshav Automobiles,
because
you do not get the power to reopen an assessment unless you have communicated the assessment. Communicated the acceptance of the self-assessment. Without that, you don't get jurisdiction to even reopen. So it's a jurisdictional issue.
Your Lordship.
Right.
Right.
We'll fix a date also for the full bench.
My lords.
We'll have it soon after the vacation.
Soon after vacation.
So 28th June.
28th June.
Interim order to continue.
My lords.
Your Lordship,
28th June. Interim order to continue. So that memo you file, please.
That memo I will file.
Tomorrow itself you can file. I mean, Monday.
Monday I will file.
And then mention it. Let her mention it. And then we'll place it on 1 p.m. or something.
My lords.
Get fully.
Supplementary list item number 35.
Please, Your Lordship. My lords, this is I am on VC, my lords. I may be submit to.
Yes.
Yes, my lords. My lords, this is a PIL filed for praying for a formulation of guidelines for immersion idle. My lords, I may express my sincere thanks to the state government. They have already made the guidelines and very nicely the immersion process has been done. And in fact, my lord, the Pollution Control Board has also formulated the guidelines following.
Yes.
Yes, my lords. My lords, it was pre-IL for formulating a guideline for immersion process of the procession and the idols, my lords. Right. And my lords, that is why I may express my sincere thanks to the state government have already formulated guidelines. And my lords,
different matter. The subject matter is different. Item 35.
Mr. Bera,
I'm sorry, matter. My lord, sir.
This is This is on health issue.
My lord, I'm sorry then. My lord, may I have 1 second, my lord, I'll verify.
This is about pre-existing medical stores to be supplied with maximum number of medicines.
I'm extremely sorry, my lord. I have same petitioner has filed another. I'm extremely sorry, my lord. I have hold.
All right.
My lord, then this matter, may I have time to verify, my lord? Lordship, may I pass over it?
All right, we pass it over.
Yes, my lord. I'm over.
Supplementary list item 36. Item number 36.
No, this is no.
Supplementary list item number 37.
Item 37, my lordship, the petitioner is challenging the order of compulsory retirement at attaining the age of 58 years in terms of Rule 44 of Odisha Superior Judicial Service and OJS Rule 2007, your lordship. I prepared a small date chart, your lordship.
We'll just take it at the end of the board, sir. We'll take it at the end of the board.
My lordship.
Supplementary list item number 38.
This is state of Orissa.
In fact, your lordship, consider the instrument order is at annexure 4. It starts from page 26. Operative portion, your lordship, page 40. Page 40. Last paragraph on close scrutiny. On close scrutiny of the confiscation proceeding made by the authorized officer and the judgment of the authorized officer, it is found that Rule 3 and 11 of the Odisha Forest Detection, Inquiry and Disposal of Forest Offence Rule 1980 have been contravened as seizure of the vehicle in connection with forest offence has not been submitted to the magistrate, and no prosecution has yet been launched against the accused for the forest offence. The contravention of Rule 3 and 11 of the Odisha Forest Detection, Inquiry and Disposal of Forest Offence Rule 19 makes the confiscation proceeding vitiated. Therefore, the order of confiscation is held unlawful and is liable to be set aside. Hence, it is ordered. By virtue of this order,
the land appellate authority, that is land district has set aside the order of confiscation.
Yeah.
This order
Must have worked itself out. What was confiscated?
This order is that is a truck. This order,
Truck?
No, this order of the appellate authority runs contrary to a judgment of this honorable court rendered by a full judge.
Mr. Mudli, Mr. Mudli.
That is
No, 1 minute, Mr. Mudli. There is no interim order here.
Yes.
That truck has been plying for the last 5 years now. 6 years, probably the truck is even off the roads. What are you going to seize? It's impractical. Even if you allow your petition, the truck was not feasible now. What truck are you going to seize? No point.
No,
you must get an interim order in these matters. If there's no interim order, then it's, see, you challenge it also so late. I noticed it's challenged after 8 or 9 months. We just keep the question of law open.
But this runs contrary to.
We'll keep the question open. We'll say it's not a precedent.
May not be treated as a precedent.
That's what we'll say that. Considering the passage of time during which there was no interim order passed with this court, and with the impugned order ordering release of, setting aside an order of confiscation of a truck of the opposite party, the court finds it impractical now to interfere with the impugned order of the learned First Additional District Judge Sambalpur in FAO number 7/4 of 2015. Consequently, while leaving the question of law arising from the said order open for consideration some other case and clarifying that it will not constitute a precedent, the petition is disposed.
Supplementary list item number 39.
May I please, Lords? Lordship may kindly peruse order dated 30/10/2017, Lords. While issuing notice, the only point for consideration before your Lordship was, the Lordship got that order 30/10, Lords.
Yeah. Yes, we have.
Whether the petitioner's statutory appeal before the CIT appeals could have been disposed of on the ground of default without entering into and or adjudicating merits of the case of the SSC appellant in the body of the appeal, Lords. So I could lay my
to CITA.
My Lords. And I could lay my hands on the judgment of the Honorable Bombay High Court, Lord, which I had shared with your Lordship, Lords. This is, of course, under Section 260A of the Income Tax Act.
So what happens if you don't appear, you dismiss it for non-prosecution?
Lord, what happens, my Lord, is this dismissal or non-prosecution, no grounds are assigned, my Lords.
Naturally.
So even if I go to the CIT, IT-80, my Lords.
No. So what happens we have under CPC Order 9 Rule 13.
Lords, there's no, my Lord. Unfortunately, my Lord, he becomes functus officio as after the dismissal.
So you can't file an application to set aside the expert order.
My Lords, he doesn't have a jurisdiction to set aside his own order.
Every time we'll come to the High Court.
Sorry, my Lords?
Every time we come to the High Court.
Every time I have to come to the High Court, my Lord. Because your Lordship would appreciate, since, my Lord, this appellate jurisdiction under the IT-80 will not be there, because I can't challenge this on merits, because no facts or law has been stated. So even if I go to the tribunal, my Lord, that has again to be set aside to the CIT appeals.
No. Now with these kind of judgments, that itself become a question of law before the IT-80.
No, that itself, but ultimately, my Lord, that has to come to the CIT appeals for adjudication on merits.
No. Next time you will go to the IT-80, I'm saying, and cite this as the law.
No, because what has happened, my Lord, is your Lordship knows, my Lord, that this CIT appeals is parametria, powers of CIT appeal is parametria to the assessing authority.
Right.
So when he adjudicates a matter, he has to discuss the merits of the matter, my Lords. Because there'll be nothing.
But if you don't even appear, what is the poor man?
My Lord, your Lordship, because they have, my Lord, the Bombay High Court has discussed.
Then you'll say in my absence he decided the merits.
No, my Lord, what has happened in this case, my Lord? The Bombay High Court has discussed the statute, my Lord, that is especially the procedure in 250 and 251, my Lords. May I just place this paragraph 2, my Lords, where they formulated the question, my Lords. Whether on the facts and in the circumstances of the case in law, the tribunal was justified in holding that the CITA...
Yes, so they went to the tribunal there.
They went to the tribunal.
The tribunal entertained it, set aside the
CIT appeal. But that was not on merits. Then, my Lords, what their Lordships have decided, my Lord, they have referred to Section 250, my Lord, the procedure in appeal, especially subsection 4, my Lords. The CIT appeals may...
No, all that I agree.
And then ultimately at paragraph 8.
Bombay, somebody said we can go to the IT-80, went to the IT-80, succeeded in the IT-80.
But my humble contention before Lordship would be, it will be an exercise in futility, my Lords. Because my merits...
Not after this judgment.
No,
because the ITAT would have remanded it to the CITA.
No, ITAT, no, again, my lord, it's a circumptuous route, my lords. Now, if your lordship would set aside the CIT appeals and send me back to the CIT, my lords, that will save all this point, both for the revenue as well as the SSC, my lords.
All right. Yes, Mr. Mark.
Because what the Bombay, but my humble contention, my lord, is there was also an honorable Supreme Court judgment, my lord, where they have said this. If your lordship would kindly turn to page 3, my lords, the powers under section 251(1)(a), my lords.
This has to be, I don't know, this has to be still hedged in with some limits. What if you don't appear before the CITA, he dismisses it for non-prosecution. You wait for 5 years, you wait for 10 years, then you go to the High Court and then say, Bombay
no, I've come immediately, my lord.
You have. So I'm just saying, in a given case.
In a given case, my lord, what would happen, my lord? If my appeal is dismissed, my lord, the assessment order revives, my lord. So I become liable for the demands which have been raised by the assessing authority, my lord,
Right.
without adjudication on merits. Here, your lordship would kindly appreciate, my lord, what was weighing with the lordships of the Bombay High Court, my lord, 251(1)(a), my lords. In an appeal against an order of assessment, he may confirm, reduce, enhance, or annul the assessment. Then B, my lords. In an appeal against an order imposing penalty, he may confirm or cancel such order or vary it so as to either enhance or reduce the penalty. Then 2, my lords. The commissioner appeal shall not enhance an assessment of penalty or reduce the amount of refund unless the appellant has had a reasonable opportunity of showing cause against such enhancement or reduction. Then explanation, my lords. In disposing of an appeal, the commissioner appeal may consider and decide any matter arising out of the proceedings in which the order appealed against was passed, notwithstanding that such matter was not raised by the commissioner appeals by the appellant, lord. And the reasons your lordship may kindly see at paragraph 8, lords.
I know, basically saying there is no provision which empowers him to dismiss for non-prosecution. No, I'm only saying there's no limit then for.
No, what has happened, my lord? Why? So far as the ITAT is concerned, my lord, the legislature consciously in the rules have incorporated Rule 24, my lords, which says that they can't pass an ex parte order on merits. It can't be a dismissal, my lords, for non-appearance, my lords.
Even ITAT.
Even ITAT. So your lordship may kindly see rules, my lord. Rules, income tax, Rule 24 of the income tax appellate rules, my lord.
So whether somebody appears or not, they're supposed to hear.
It's something like a criminal appeal, my lords. It can't be disposed of.
So here, one of the first questions you will raise here is, it was decided without hearing me.
the income tax appellate tribunal rules, my lords.
I know.
May just.
I think it's very unfair to those tribunals.
Sorry, my lord?
It's very unfair to those tribunals.
The income tax appellate rules, my lord.
See the bonus that judges get for dismissing for non-prosecution.
Lord, well, that is the reason, my lord, where statutory authorities, while discharging statutory powers, they should not think that they are in a 226 jurisdiction. 226 is something much different, my lords.
So rule?
Rule 24 of the income tax appellate rules, my lord.
Yeah, appellate tribunal. Yeah, 3 point.
Rule 24, my lords.
Right.
This was an amendment which was brought. Previously, my lord, the old Income Tax Act was Rule 20. There was a power to dismiss.
Right.
Then for the problems, they added a proviso where they gave the power to restore ex parte orders, my lords. Then, my lords, after this 60 Act came into place, the Rule 24 is there, my lords. Your lordship got Rule 24?
Yes, where on the day fixed?
Sorry?
Where on the day fixed?
My lords. I'm sorry, I have not got that rules. That's there may be some communication gap.
It's here. On merits after hearing the response.
Your lordship got it?
Right.
This was Lord, interpreted by the Honorable.
They have to first pass a whole order on merits. Then the man will come and say,
that
no,
is-
no, I
that
could not
is-
appear. They have to restore and again hear him. So you end up writing 2 judgments instead of 1.
Lord, here, Lords, this particular provision, this particular provision has been interpreted by the Madras High Court also, my lords, saying that the ITAT has to hear it on merits,
that's-
and they have said, my lord, it's something like the criminal appeals, which cannot
No, you have to give 2 judgments here.
ready.
That's right. And you may contradict 1 judgment, of course,
Minus.
because after hearing the appellant, you may change your mind.
Change of opinion.
So,
Lord, if your lordship may
a
also
lot of
take,
hard work for the tribunal.
sorry, and there's also a judgment of this.
You have to hear him after hearing the respondent. And then this man will come around and say, I couldn't appear because car broke down, bus broke down, something, and then you have to
For a moment, 250 subsection 6, 251(6), my lords. Sorry, 256 of the Income Tax Act, my lords.
No. Yeah.
50, my lord, procedure in appeal.
Act.
Subsection 6.
Supplementary list for orders, item number 1.
For the reasons mentioned in the memo, the review petition is permitted to be withdrawn.
Okay.
And it's disposed of.
This party. I'm for the opposite.
All right. All right. All right.
You should also adopt this.
Supplementary list for admission, item number 1.
May it please your lordships. My lords, there being difference of opinion in two judgments, that is Jindal Steel and Pal Construction. Now the question has been referred before this larger bench as to whether the word shall used in subsection 4 to section
77
41 of the OVAT Act, where the audit report has to be submitted within 7 days from the date of the completion of the audit.
Is it mandatory or directory?
It is mandatory. Now, these intriguing questions had been the subject matter, had drawn the attention of the Apex Court and different high courts for quite a long time. And this question, when the word is used as shall or is may, whether it can be construed to be mandatory or directory. This question is to be, in order to ascertain this, when there is a word may, suppose say may, whether in that case it can be directory or it can be mandatory. Then your lordship, what the Supreme Court did, Supreme Court and also various high courts have also evolved a test. The test is the intention of the legislature. First, I will bring to your lordship's kind attention to the judgment of the Constitution Bench.
Why don't you sit down, Mr. Acharya?
Lordship may kindly see State of Uttar Pradesh and others, Baburam Upadhyay.
61 Supreme Court.
Yes, madam. Page 29 it starts, and the relevant paragraph I'll bring to your lordship's kind attention.
What about the other two learned judges?
Here, my lords, Justice Vanchu deferred, and 4 others concurred with Justice Subbarao. The author of the judgment was Subbarao, Justice Subbarao.
Right.
29. Just page 29 it starts, my lords. 29 it starts. Justice Sarkar, Mudhalkar, Subbarao, Vanchu and P.P. Gajendra Gadkar. And the author of the judgment was Justice Subbarao. And your lordship will kindly see what the majority of the judges held, that is at page 42, para 32. Before we consider the principles governing the question whether the rules are mandatory or directory, it would be convenient at this stage to notice broadly the scope and purpose of the inquiry contemplated by the rules. Here, now, lordship may kindly turn to para 36 at page 43. The question is whether Rule 1 of para 486 of that Police Act is directory. The relevant rule says that the police officers shall be tried and place so and so is not that important. The word shall in the ordinary import is obligatory, but there are many decisions wherein the courts under different situations construed the word to mean may. This court in so and so decision, therefore the important passage is in para 38. That is at page 44. The following quotations from Crawford on the construction of statutes, page 516, is also helpful in this connection. The question as to whether a statute is mandatory or directory depends upon the intent of the legislature and not upon the language in which the intent is clothed. The meaning and intention of the legislature must govern, and these are to be ascertained not only from the phraseology of the provision, but also by considering its nature, its design, and the consequences which would follow from construing it the way or the other. This passage was approved by the court, by this court in the state of UP versus Manbodlal Srivastava. The Supreme Court is Manu Supreme Court. and 1948 IILLJ.
Para 40 is most relevant for us.
Yes, valuable guide, yes. Valuable guide for, quite right, my lords. For ascertaining the intention of the legislature is found in Maxwell on the interpretation of statutes, 10th edition, at page 381, and it is, on the other hand, where the prescription of a statute relate to the performance of a public duty, and where the invalidation of acts done in neglect of them would work serious general inconvenience or injustice to persons who have no control over those entrusted with the duty without promoting the essential aims of the legislature. Such prescriptions seem to be generally understood as mere instructions for the guidance of the government guidance and government of those on whom the duty is imposed, or in other words, the discretion only. The neglect of them may be penal, indeed, but it doesn't affect the validity of an act done in disregard of them. This passage was accepted by the Judicial Committee of the Privy Council, case of Montreal Street Railway Company versus Normanin LR 17 Appellate Court 170, and in the case of, and by this court in state of UP versus Manbodlal. So, my lords,
in the case on hand, how do you apply it?
My lords,
what is the wording of section 44?
Here, my lords, I'll come to that. My lords, your lordship, I'll just point out another decision, thereafter I'll come. That is, my lords, the first one, State of Mysore versus B.K. Kangal. And the relevant page is page 3, para 10. In determining the question whether a provision is mandatory or directory. My lord, got it.
But none of this is in a tax statute. This is also land acquisition, that was police rules.
And it is not, but the principle is same.
No,
the intent of
also,
the most...
You have to apply the Maxwell.
Yes, the intent of the legislature is important.
No. What is the consequence of not treating as mandatory? That is the consequence of that is important.
Exactly, my lords. Now, my lords...
No, you don't have any tax statute judgment.
And the tax statute judgment, unfortunately, I didn't have, but...
So let us see the wording here.
Yes, lordship, before that, may I say one thing? The triggering point of this audit assessment is the audit. 41.4 says audit will be conducted.
Let's read that.
41.4 of the VAT Act. Lordship knows. आगे तुम सही 41.4 subsection 4 to section 41, which says that
after completion of tax audit of any dealer under subsection 3, the officer authorized to conduct such audit shall within 7 days from the date of completion of the audit submit the audit report to be called AVR. So audit based report or AVR to the assessing authority in the prescribed form along with the statement recorded and documents obtained evidencing suppression of purchases, sales or both erroneous claim of deduction including input, etc., etc. Now, my lords, the assessment starts. No, this is pre-amendment, post-amendment.
No, this is pre-amendment.
Pre-amendment.
Post-amendment also, they have post-amendment. They have to post-amendment is which was from
post-amendment. It is after completion of tax audit of any dealer, the officer authorized to conduct such audits will determine the liability.
Yes.
And serve a notice.
Yes.
So
and he will bring to the,
it's different.
And he will bring it to their note. We are not concerned with that matters. We are more concerned with this. Whether the audit officer is coupled with a duty to dispatch or to submit his report to the assessing officer. because my lord, the entire VAT regime, immediately after the sales tax regime, the VAT regime, the emphasis was in a time-bound manner. It is the assessing officer on the receipt of the audit visit report, he will immediately communicate it to the assessee, and my lords will kindly see 42(5) of the OVAT Act, the assessment starts. And there also 42, it has audit assessment. Oh, sorry, 42(1), my lords. 42(5) is penalty and 42(1) is audit assessment. And the rule says, my lords, the rule 49 says that there will be maximum 3 adjournments. No more adjournment. This is a time-bound schedule because the revenue should not be in a loss. They should not also put to any loss, nor the assessee. It is totally a time-bound frame, and he has to frame the assessment within 6 months, or else before expiry of 6 months. Lords, we have earlier also delivered the judgment on this, that Cobra International, in so many cases, there before the time expires, he has to submit it to the commissioner for getting approval for extension of time. Now, so the mechanism under this VAT Act is time bound, totally time bound. So if the audit of after completion of the audit officer sits at his sweet will with the audit report and sends it after 4 months or 5 months, then what happens, my lords? The triggering point is the audit assessment, and audit assessment is delayed because there is he gets the audit report after a belated time, and he immediately, my lords, and he has to issue the notice, not giving less than 30 days notice to the dealer for making appearance. And under Rule 49(4), my lords, he cannot give more than 3 adjournments.
No, so tell us which judgment held it to be mandatory, which was said directly.
Yes.
What did Jindal say?
My lords, the intention of my humble submission before...
No, two conflicting judgments.
Yes.
Jindal Stainless said what?
Jindal Stainless Steel says within 7 days.
Mandatory.
Mandatory.
And then which is the other one which says it's directory?
Directory, PAL says.
Which is later? PAL is later.
PAL is later.
PAL's is an order. PAL says that Jindal still doesn't lay down the correct view. So therefore, they have referred. They have deferred.
Where is PAL?
PAL I'm giving. Right? They don't. Yes, my learned friend is giving ballots. I have the judgment, but he has.
This is downloaded from the.
Yes.
That case also listed. That case has been listed on.
No, this is just a referral order.
Referral order.
Yes.
Only referral.
This is the order.
Para 5, on the above backdrop, the following question is referred to the larger bench. Whether non-submission of the AVR to the assessing officer within 7 days from the date of the completion of audit as contemplated under section 41 within bracket 4 of the OVAT Act renders the audit visit report invalid, and the assessment made on the basis of audit visit report is illegal. Now, my lord was asking me a question whether I have got any judgment on the taxing statute.
No. 1 minute. The referral order does not refer to the judgment in.
Exactly. It doesn't refer. They only say.
Then how can it go unless they doubt the correctness of the judgment?
Yes.
The correctness of a judgment has to be doubted. No?
Doubted. Yes.
If there is no doubt about the judgment, how does it get referred to a larger bench?
No, Lordship, that is
No, a coordinate bench's judgment is binding.
Your Lordship. Your Lordship may kindly turn to the previous page, order number 37, this Honorable Court. The entire order, Your Lordship may kindly look into. In support, Your Lordship, paragraph 2. Dated that case also has been listed, Your Lordship may kindly look into the order sheet.
All right.
Dated 20th/10/2014.
All right, 1 minute.
Malam. 16,957, 2009.
That's the first one, in fact.
Your Lordship, the first case. At paragraph 2, Your Lordship, at paragraph 2, although several grounds have been taken in the writ petition to challenge the assessment order, Mr. B. Pandal and a senior advocate for the petitioner confined his argument to one of those grounds. According to Mr. Panda, the audit in the business premises of the petitioner was conducted on so and so, and the said report was signed by sales tax officer on so and so as revealed from the AVR. The said report was received by the assistant from the sales tax officer audit unit on dated 16/10/2006. The authorizer has not submitted. Date of completion of audit as contemplated in the audit.
No. My point is simply this.
The next page.
Yeah. The points of issue involved in the present case are extremely important, especially the issue raised on behalf of the revenue vis-a-vis the impact of judgment relied upon the real counsel petitioner and the interpretation. But where is it saying that we have a doubt as to the correctness of the division bench judgment? See, the normal thing, let us look at two single judges. All right.
Your Lordship.
A single judge's judgment is referred to the single judge. He has to, in his order, say, I am not in agreement with this view expressed by my learned brother. Therefore, I'm asking the matter be placed before a larger bench. Likewise, a division bench has to say, we do not agree with the view expressed and therefore place it before a larger bench. I can't simply refer it to a larger bench. Only this
correct
pre-lunch session. We referred the correctness of another judgment to a larger bench.
Correct. Now, my lords,
and also reason has to be given.
That's right. Why they differ? Do you agree, Justice Mahapatra?
Yes. That should. First of all, the court has to, the bench which refers the matter to the larger bench has to raise the doubt about the correctness of the
correct.
Exactly.
They have to frame the questions.
Correct.
Referral judgment should frame the questions.
Correct.
That these are the points which require the attention of the larger bench.
No, exactly. You'll have to say why that earlier judgment, according to us, is wrong.
Yes.
And therefore, sometimes it may not have noticed a Supreme Court judgment. Sometimes it may not have noticed a provision of law.
Yes.
And thirdly, of course, we may take a different interpretation. We may think that interpretation is incorrect, and therefore we refer it.
Only at paragraph 4, Honorable Court says that the point of issue involved in the present case are extremely important.
No.
That cannot be probably that cannot be a ground.
Correct.
Your Lordship.
Correct, man.
And also, Your Lordship, one more aspect, the reference, Your Lordship, factual aspect, but in spite of the law, Your Lordship, in all these cases, we have complied.
That becomes academic now. That becomes academic now.
Yes, Your Lordship.
Yes, that becomes academic. Since the referral judgment does not cast any doubt on the question of the correctness of Jindal Steel, the other things becomes totally academic.
Right.
Your Lordship, let all these cases be placed before division bench for factual adjudication.
Now, factual adjudication as well as the law. The bench is exercising the power under Article 226.
Right.
Both.
Right. In fact, this is not a case of conflict between two judgments.
Exactly, my lords. Exactly.
Correct. You see, in fact, the leading judgment is of the Supreme Court in Raghuveer Singh in the land acquisition cases. Justice Pathak's judgment because of stare decisis. That is, if it's a two-judge bench, it's bound by another two-judge bench, unless it differs and then refers it to three-judge.
Mallards. It is reported in Mallards.
Yes.
Can I question Mallards? It is reported. Can I know the citation exactly?
It's a 1989, 88 or 89.
1989.
Raghuveer Singh.
Well,
it's in the Land Acquisition Act. Yeah.
Much obliged.
I'll quote it in the order when we. You say, So Justice Rautre will say that this is not to be referred because.
Yes, yes, sir.
All right. You say the present petitions are listed before this larger bench on account of an order passed by a division bench of 2 learned judges of this court on 20th October 2014 in writ petition civil 16957 of 2009, which reads as under, reproduce the order.
Your Lordship, 15962.
No, 16957.
16957.
957. Oh, sorry.
No, the order referring is that.
I'm sorry.
Paragraph. The question involved in the present petition concerned interpretation of section 41 bracket 4 of the Orissa Value Added Tax Act 2004 as it stood prior to its amendment by virtue of the Odisha Value Added Tax bracket Amendment Act 2015 with effect from 1st October 2015. Full stop. In terms of the unamended section 41 bracket 4 of the OVAT Act, no, section 41 bracket 4 of the OVAT Act read as under. So reproduce 41.4 prior to the amendment. Paragraph. The question was whether the requirement of the audit report, requirement of the authorized officer having submitted to the having to submit the audit report to the assessing authority within 7 days from the date of completion of the audit was mandatory or directory? Question mark. Paragraph. The counsel for the petitioner had cited before the division bench of this court the decision of another division bench of this court comprising of 2 learned judges in Jindal Stainless Limited, bracket now JSL Limited, bracket versus State of Orissa, 2012, 54 VST 1, bracket Orissa. Paragraph. After noticing the said judgment, the division bench of 2 learned judges in the referral order proceeded to state that the points of issue involved in the case, open quotation, are extremely important, especially the issue raised on behalf of the revenue vis-a-vis the impact of the judgment relied upon by the learned counsel of the petitioner, unquote, which is the judgment in Jindal Stainless Limited, Supra, regarding the interpretation of section 41 bracket 4 of the OVAT Act as it stood prior to the 2015 amendment. Paragraph. In the considered view of the court, a division bench of 2 learned judges of this court is bound to follow a judgment of a coordinate bench of same strength, and if it chooses to differ from the said judgment, it is only then that the matter can be referred to a larger bench by stating the points of difference with the judgment of the coordinate bench. Full stop. This rule of stare decisis is well settled and has been explained by the Supreme Court of India in Raghuveer Singh versus Union of India in the following passage.
Union of India versus Raghuveer Singh, the 1989 volume 2 SCC 754.
89.
1989 volume 2 SCC 754.
Thank you. Thank you. 1989 2 SCC 754 in the following passage. It's a classic passage. Actually, Justice R.S. Pathak writes beautifully. He writes very short judgments, Justice R.S. Pathak.
He writes
but very crisp, very lucid. Like Justice A.N. Ray. Justice A.N. Ray wrote very crisp, very short judgments, but to the point.
Correct.
And very good language. Paragraph. With the order dated 20th October 2014, not stating the reasons for differing from the judgment in General Stainless Limited, Supra. The question of a larger bench considering the issue does not arise. Full stop. In fact, a referral order properly framed should set out the points of difference from the earlier, from an earlier judgment with which the bench is differing. Full stop. That, however, has not been done in the referral order dated 20th October 2014. Paragraph. In that view of the matter, the court declines to answer the reference made to this bench, larger bench, and places all these matters before the roster bench to be dealt with on merits in accordance with law.
Your Lordship, these cases may be posted before Your Lordship. Why? Honorable Justice Rahman is concerned in some of the matters. Counters are
let that happen. He will say it and then it will.
Interim orders to continue.
Yeah, the interim orders will continue, obviously.
Yes. Maybe
Your Lordship.
We'll let's place before the roster bench on 13th April. 13th April.
Your Lordship.
13th April. Much obliged.
All right.
Get fully.
Much obliged.
Weekly list old matter item number 1.
This is okay. It has to continue from where we left off, right? You were on your leg.
Yes.
You take us. Let him take us through. He was on his legs. Is there any notes at this side? Check it.
May I please?
Yes, please.
Lord, my Lord and friend has already placed all the evidence of the witnesses, and apparently, two independent witnesses, 4 and 5, they turn hostile. But from the family members, PW 1, 2, 3, they are the now the
only surviving witnesses.
Yes, out of this 1, 2, 3, they are to be scanned whether
they're all related witnesses.
Related witness, and PW2 is the only witness who has in fact has seen the entire occurrence.
It's a wife of one of them, right?
Pardon?
It's a female.
Is the brother of the
brother
of the PW2 is done.
All right.
Because it was earlier there was a dispute relating to witchcraft. That is why there's a dispute arose, and a meeting was convened in the village. Thereafter, they committed offense. Again, I want to read the statement of the evidence of the PW3. It's a small evidence, my lord. Your lordship kindly have a glance to the evidence of PW3, wife of the deceased. And there is my friend has raised one objection. The evidence has come out that at the time of occurrence, there is identification is doubtful. Is 2 point is identification is doubtful due to absence of light. Yes.
One pole, one light.
Yes, so that is that dispute. And furthermore,
and some 15, 16 people are named.
And he has not specifically named any overtact has been attributed to anyone. He has only said that accused persons. But that is I'm referring to the evidence of PW3 is the wife of the deceased. My lord, kind of running page 136.
Right.
I may read, my lord. Running page 136. The paper book. I know all the accused persons present in the dock. They are my co-villagers. PW1, who is the informant in this case, is the younger brother of the husband. PW2 is also younger brother of my husband. About 2 years back, on a winter night, while I was sleeping with my son Brajakant and my late husband Chandrasekhar, at about 9 p.m., accused persons. Kindly have a glance, my lord. Accused persons he named specifically Kalia, Chandrakanta, Mata, and Dilip Kumar Malik forcibly entered inside our house by breaking open the door and cut hold of my late husband and assaulted him, dragging him outside to Danda. At that time, PW1 and 2 were present. In our Danda, in front of our house, other accused persons, being armed with kati, thenga lathi, assaulted my husband. He has not named any other persons. She could able to identify only 4 persons. When I followed my husband to the underside, I was assaulted by the accused persons, on which I fell down on the ground. Thereafter, the accused persons, after assaulting my husband, carried him away towards the Talasai of our village. In cross-examination, on the night of occurrence, when 4 accused persons, as noted above, forcibly came inside our house by breaking open the door, a debris light was burning, but there was a street electric light in the Danda in front of our house. In the debris light, I identified the accused 4 persons. Was for a moment, my lord. This thing. My lord, my humble submission before Lordship, my lord. Apparently, PW1 and 2, they are the brother of the 1 and 2 were the brother of the deceased, and they are saying only in the evidence that we have identified the accused persons, but without attributing any persons. And of course, it is doubtful when the DW officer is coming and deposing that there is no supply of electricity. So identification may be doubtful. You also rightly pointed out. But so far, the identification of 4 persons at least. These 4 persons who are entered inside the house of the PW3, of course, he has not seen the assaulting part. But dragging her husband from their house, these 4 persons were correctly identified in debris light. That let's say kerosene.
No, was the debris light seized?
Debris light, my lord, no such question has been put.
Then that becomes a very crucial piece, right? If the debris light is not seized.
In cross-examination that nothing has been put out to
Let's read it fully then. Let's read it fully then.
It is not a fact that I have not mentioned the name of the Dilip Naik in my statement before. On the next day of morning of the occurrence, G. Udayagiri police visited.
Oh no, what is the fact? It is not a fact I have not mentioned. What does the 161 say? Does she mention?
Yes, it is not a fact that I have not stated before the IO that on the night of occurrence, I saw PW1 and 2 standing outside the house.
Where are you reading, sir?
That I am not. So far the confrontation is concerned, it is I recognize the accused persons in Danda. Paragraph 3.
No, where are you reading? No, but he's jumped. I'm saying the first confrontation, it is not a fact. I have not mentioned the name of Dilip Naik. What is the correct position? In 161, she has mentioned or not mentioned?
Well, in the FIR it is mentioned. And
sir, when she's confronted, she's not confronted with the FIR, she's confronted with the 161.
161 statement.
Does the 161 name Dilip Naik or it does not?
Well, Dilip Naik, he says that I'm reading to the evidence of the IO, so that.
All right.
I read your lordship.
PW3, it's 155, page 155. PW3, wife of the deceased has not stated before me
So which means her
specifically that
denial here is false,
in the
sir.
debris light, he identified the accused Nayak, Mata Nayak, Chandra Pradhan and Dilip Kumar Malik. PW3 has not stated before me that on the night of the occurrence, she saw PW1 and PW2 standing outside their door in the village Dando. So this is a new version is saying that I identify in debris light. He has not stated before the IO that I identify these persons with the debris light. This is
No,
a new
debris
thing
light
is-
is one part. She also did not name accused 1 or 3. Dilip Nayak is what? Accused number 4. See, in her cross-examination, she's confronted with her 161. And she says, she denies that she has not said, which means, according to her, she did tell the police that Dilip Nayak is involved. What is the actual position in the 161?
It is stated that it is not a fact that I have not mentioned.
So double negative, sir. Not a fact that I have not mentioned, which means in her 161 she has mentioned.
Yes, yes.
What is the factual position? Has she mentioned or she not mentioned?
161, we don't have the 161 statement.
No. IO was the IO asked. What has she said in her 161?
So for Dilip Nayak is concerned, that confrontation is not to IO. To the IO, that line is not there, my lord.
See, we are testing the credibility and truthfulness of a witness, correct? Normally, she's shown the 161. The correct way of cross-examination is show the witness the 161.
Yes.
And say, where have you said about anything about Dilip Nayak? She should say, yes, I have not mentioned Dilip Nayak, or she should say, no, I have mentioned. Despite the 161 not mentioning Dilip Nayak, she tells the court, no, I have mentioned, which means she's not a reliable witness.
So for Dilip Nayak, no such. It is only a suggestion, my lord, but nothing has been put, no question has been put to IO, my lord. So far Dilip Nayak is concerned.
No, so far as PW3 is concerned.
Dilip Nayak is concerned, my lord.
No. So far as, see, what will be put to the IO is whether this witness said this to you or not.
Yes,
That's
that
what
is
it
to be
is.
put, my lord.
Anyway, all right, you continue. I showed them the debris lamp. Police saw it. So all this is wrong. Because the IO is saying we never saw debris lamp. She
Debris
never
light
pointed out.
is, IO has stated that this, so for that line is concerned, debris light, the identification of 4 persons, that I have identified 4 persons in the debris light, that has been put to her, that for the first time says, it is appear from the evidence of IO.
No, just imagine the question. When she's asked, she must have been asked, is there a street light in front of your house? Right?
Yes.
To which she says, but there was street light. Why she asked that? Because a debris light, the first line she's saying, a debris light was burning. The question, see, unfortunately, we don't record questions. The questions asked in cross-examination should ideally be recorded and then answer given.
Yes.
Since we don't record the question, we have to guess what the question must have been.
Oh, yes.
So the question must have been, you identified 4 persons. How did you identify? Right? What is the date of our examination? Just let's look at that's also important for us. 10th January 2000. All right. Carry on, carry on.
Yes, my lord.
I think it was January 2000 after the other two witnesses have been examined. Right.
So, my lord, the evidence of that PW3 that she has stated it is in paragraph 2. It is not a fact that I have not mentioned the name of Dilip Naik in my statement before the police. On the next day morning of the occurrence, G. Udayagiri police visited our house. I showed them the debris lamp. Police saw it. Police took it and after 2 days returned it. Due to assault by the accused persons, even though I fell down, I did not lose my sense. It is not a fact that I have not stated before the IO that on the night of occurrence, I saw PW 1 and 2 standing outside their house in the village Danda. After I was assaulted and fell down, I myself stood up and nobody had carried me inside my house. When I stood up, I saw the accused persons have already carried away my husband after crossing the village well on the night of occurrence. My neighbors, namely Bada, Baji, and Luti, have seen the assault on my husband.
No. Who's these? Are these three examined, sir? Veda, Baji, and Luti.
Bada, Baji, and Luti. Bada, one is not at PW. Bada is on PW4.
He's turned hostile.
Hostile. And Baji and short name is here stated. Baji and Luti probably they have not been examined. Or because PW5 is the Loknath, name is Loknath.
Now look at para 3 again, running into difficulty. First line of para 3.
Para 3, I recognize the accused persons in Danda by street lamp. Due to fall, I had very little minor injury on my forehead. Police had seen the injury. It is not a fact that on the night of occurrence, no street electric light was burning in front of our house. It is not a fact that I had not seen any of the accused persons at the spot, nor I had seen any assault on my husband. It is not a fact that my husband on the date of occurrence during daytime left the village and is untraced since then. It is not a fact that being tutored by my dear, namely Subhas, I am deposing evidence today. It is not a fact that as the brother of the accused Dilip, this is Pradeep, had ailment due to the influence of sorcery, and he and his relatives came to our house to take the over rice of my husband, but my husband refused to give it. So, my lord, my submission before lordship, though this, so for the identification of these three persons, my lord, in cross-examination,
Kalia Chandrakanta Mata.
Manda. These things has not been suggested, my lord, in cross-examination.
No, but here's a witness who's saying first debris lamp. Within 2 minutes, she's saying street lamp.
No, he's double. Because debris lamp was, he's saying that it debris lamp it was inside her house. She could able to identify these four persons, my lord.
No, sir.
Debris lamp.
Just let's read this thing very carefully. Para 2 beginning.
Para 2. Again, I'm reading. On the night of occurrence, when the four accused persons, as noted above, forcibly came inside our house by breaking open the door, a debris light was burning. So, my lord, debris light was burning inside her house.
No. Read on, sir. Don't read. Stop reading. You have to read 3 lines and then make your submission.
Yes. But there was street electricity light in Danda in front of our house. In the debris light, I identified accused Mata Naik, Chandra Pradhan, Dilip Kumar Malik.
So stop here. How did she identify?
In the debris light.
Now come to para 3 beginning.
Para 3. I recognize the accused persons in Danda by street lamp.
Now stop here. So what is she identifying? Is she identifying by the debris lamp or is she identifying by the street lamp? Now she wants to stand by the street lamp theory. So she says it is not a fact that in the night of occurrence, no street light, no electric light was in the street. So look at this. The witness has now changed her mind how she identified. She's walked into a trap. That's why the defense lawyer stopped after this, because he knew he had trapped the witness. After making her say that she identified by debris lamp, he made her contradict herself. See, the defense lawyers know there is no street lamp, because they are going to bring in the electrical inspectors. They know there is no street lamp, so they're nicely laying out a trap for the prosecution witnesses, telling them to speak about street lamp, and they're happily saying it.
And the story of that identification of debris lamp is not from the genesis, from the very beginning.
So who asked her to
FIR
speak?
it is also
So
mentioned.
some prosecutor must have told her, listen, the street lamp is proving to be problematic. Talk about some debris lamp.
Yes, my lord.
This is the problem when you suddenly start telling a witness, please give some alternative explanation.
Here she is referring, my lord, to all the accused persons. I recognize the accused persons in the danda.
See, ultimately, as a court, we have to decide on the strength of this kind of evidence. Can we send 4 people to life imprisonment? Can we trust this kind of a witness?
First, my lord, she has in the one line she has stated that I identified in debris light. Now she's saying that I recognize the accused persons in danda by street lamp.
See that now it is very clear there was no street lamp. Nobody applied for electricity. The village never got electricity. Even when they were examined, there was no street lamp.
Time she has deposed for the material, there is material omission. For the first time it was confronted to the IO, she has stated the relevant part in paragraph 10 that I suggested. It is not a PW2. It's important. There is an important omission is there. Paragraph 10. It is not a fact that I have not stated before the IO that since the accused persons threatened to assault, I return home from the village. Well, on that night, it is not a fact that I have not stated before the IO. On the night, I saw the deceased brother lying on the crib. So this is the important line which is he has omitted that. So in this court, solely that witness cannot be it is not my concession, it is subject.
No, correct.
It may not be accepted because he has. It is an important omission.
See,
because
in a direct evidence case, there must be at least one trustworthy witness.
That is sufficient,
But so there is not a single trustworthy witness.
This witness, because the material omission he has, that is why I am confining to PW3 evidence. But our evidence is so far those three accused persons is concerned. Kalia, Chandrakanta Mata, and Dilip Malik. But her evidence is that so far the identification is concerned. In the one line, she is saying that In the debris light, I could identify all those accused. But my lord, it is from the in the chief, my lord, she has stated that I identified from the debris light, and in cross-examination, in the debris light, my lord, she has it in the positive ballot evidence in the paragraph 2, my lord. In the debris light, in cross-examination, they brought out, my lord. That is my only submission. Your lordship may kindly note, my lord. In the chief, at the mallet, once again, your lordship kindly have a glance.
No. In the chief, she doesn't say how she identified at all.
Yes, mallet.
No. In the chief, there is nothing about any light.
No, so far the identification is concerned, she has not stated.
That's why in the cross you start with how did you identify? Because in the chief, she's saying nothing about whether there's a street lamp, debris lamp, nothing.
That she has not. She is saying that I identified those 4 persons. She has not named another person.
Correct.
But in the cross-examination, they brought out regarding 4 persons that regarding identification.
No, they brought out the contradictions, please. First, she said debris lamp. In the next, within 1 minute, 2 minutes, she's talking of street lamp.
It is subject to your lordship's acceptance, my lord. In the chief examination, she only says that, stated that she had identified 4 persons and saying that other.
She doesn't even say I identified. She just names 4 persons.
Named 4 persons. Thereafter, in cross-examination, it was brought out by the defense that she could identify those 4 persons in debris light.
Not only that, that's why the defense has done 2 things. After getting her to commit herself to debris lamp, she walks into the trap when they talk to her about street lamp.
This line is mallet only. I'm giving stress over this for 1 line, mallet. In the cross-examination, in the chief, she is saying that at about 9 p.m., accused persons naming Kalia, Chandrakanta, Mata, and Dilip Kumar Malik forcibly entered inside our house by breaking open the door and caught hold of my late husband and assaulted him, dragging him out through Danda. Then it was brought out by the defense in cross-examination.
And she's also saying at that time
the
PW1 and PW2 were present. Just see that. She also adds at the time PW1 and 2 were present.
Yes, sir. PW1 and 2, she is saying that PW1 and 2 were present there.
Whereas, again, that is contradicted in the cross-examination. She never said that. The IO also says she never said it. She doesn't talk of PW1 and 2 in her earlier statement to the police.
She has
so basically, she has said 4 things in the chief. All 4 things are disputed.
This witness, there are 3 types of witnesses: partly reliable, wholly reliable,
wholly
partly
unreliable,
reliable, partly unreliable,
and wholly unreliable.
Only unreliable. So this witness is partly reliable and partly unreliable.
No. All right.
Yes.
Anything else? That's it.
That's it. Because other 2 eyewitnesses are turned hostile. Entire case rests on those 3 witnesses.
Just one decision on the point of light, your lordship. That is 2019 2 SEC criminal page 875. That's a I'm class term penal code 1986 section 302 34 307 by 34 IPC murder trial. Death of one due to shooting on the injury to others. Alleged main assailant appellant alone be made responsible. All others standing acquitted. Author of the fatal firearm wounds. Identification of accused on the night of darkness. No evidence at the source of light. Conviction reversed. Just one paragraph, your lordship. Paragraph 12. The occurrence was on 23/11/1997 at about 9 p.m. in the agricultural field of the complainant Sobani Rupa Bhai, PW3, where it was dark. The Panchanama of the sense of the occurrence exhibits P73 shows no indication of electricity light either in the animal shed situated behind the house of complainant or that there is any electricity pole anywhere in the vicinity or there was any light as well as which is supplying of water. Case of the prosecution is that the appellant and 6 other co-accused surrounded the complainant party and there was gunshot fired. The injury witness number PW6 in his cross-examination has admitted he had not stated anything about the burning of light either in the animal shed or anywhere in the vicinity. The absence of any evidence as to the light aspect, the possibility of identification of the accused in the darkness in the agricultural fields of the complainant, particularly at 9 p.m., becomes doubtful. Your Lordship, I have a much good case than this decision, Your Lordship. In PW1, in his cross-examination, said that it was a dark night, and without this, the occurrence was a dark night. On the night of occurrence, electricity bulb was burning on the veranda, and also there was a street light in front of house. Had there been no electricity light in that night, I could not have identified
This
that.
is all the trap you people laid out for the witness. And they walked into it.
Well,
Anyway, all right. Just give us a photocopy of the judgment. Can you do one favor, sir? That 161, just look into the case diary or something. Ask the IO 161 statement.
I can verify from the LCR, my lord. 161
you
is
can
there.
just place those one with your written note.
That specific that line, my lord.
We just want to know on PW3
Yes, my
161.
That let me verify from the.
another point, Your Lordship, no dead body was recovered. Some bones were recovered, and that was
Not sent to the DNA.
No sent to the DNA.
But so far, if that will, my lord, from appear from the evidence of the statement of the witness PW3 regarding the complicity of those 4 persons, at least their last scene that they dragged the accused person, that is there. But the remaining part is, of course, he is not an eyewitness to the occurrence.
All right. Orders reserved. The parties are permitted to file their written notes of submissions within 1 week. All right.
Item number 2. I'm not password, Mr. Katkia. Because there is election, another case is coming.
All right. But let him start.
My lord.
Under conviction, my lord, under section 302 and 307, my lord. So far, 302 is concerned, my lord, life imprisonment, and 307, 5 years conviction and fine, my lord. In this
How
case,
much
my
has
lord,
he served, sir?
My lord?
How much did he serve before coming out? How many years did he serve before coming out?
Sir, my lord, he was arrested in 2003, my lord, and granted bail 2010, my lord.
7 years.
7 years, my lord. And in fact, in this case, my lord, the appellant is the husband of the deceased, my lord. My lord, admittedly, prior to the incident, my lord, there is a 498 case registered against the appellant, my lord, and the petitioner, the appellant, his mother and sister was arrested in that case. That case is pending by the time when the occurrence took place, my lord. And another thing, my lord, on the particular date, my lord, this appellant took poison and admitted in the hospital. That is admitted fact. That is a case of 309 is there, my lord. In fact, in this case, my lord, there is only eyewitness, injured eyewitness, mother-in-law of the appellant. PW 19, my lord. But the doubt creates, my lord, the father-in-law is the informant in this case. But I place first the FIR, my lord, at page
30.
My lord, 34, my lord.
Right.
34, my lord. PW 10, my lord, is the scribe of the FIR, my lord. As per the FIR, my lord, the PW 1 is not the informant, my lord. Father-in-law of the appellant, my lord, he is not an eyewitness to the occurrence. Hearing the statement, some villagers, he lost the information. And PW 10, my lord, is the scribe of the FIR. He admitted in his cross-examination that I have not seen the house of the accused Govinda. I have seen the accused early occasion. I have not given any certificate in the FIR that I have read over and explained to it through the informant, my lord. So, my lord, FIR itself creates doubt as because the FIR was written by the PW 10. Though PW 10 signed in the FIR, my lord, there is no such certificate or endorsement with regards to read over and explain to them. But it creates one doubt, my lord. Second thing, my lord, PW 19, my lord, who is the sole eyewitness to the occurrence, my lord. She stated that she regained her sense, my lord, after 4 days of the incident, my lord. But she stated that IO examined her after 10 days of the occurrence, my lord. So, my lord, if she regained the sense after, my lord, 4 days, my lord, the IO, even if not examined her after 4 days, my lord. I was stated that he examined the PW 19 on 26th, my lord. Date of occurrence 8, my lord, 8. And after, my lord, 18 days he has doctor examined. My lord, it creates doubt. The veracity of the evidence of the PW 19 is doubtful, my lord. As because there is admittal, there is enmity, my lord.
Let's read her evidence.
My lord, PW 19, my lord.
Yes. Uni Mishra.
My lord, my lord. Lord, below 968, page 68. I know the accused present in dock, who is my son-in-law. This is Rajeshwari Mishra, is my daughter. This is was given in marriage to the accused. After the marriage, my daughter was staying in the house of her husband. My daughter was subjected to cruelty for demand of dowry by the accused and other members of his family. So my daughter came to my house and stayed with us. The occurrence took place in the month of last Chaitra at about noon. On the Tuesday, myself and my daughter were arranging for Mangala Puja, and the accused entered inside her house being armed with a tabli and threatened us to kill. And so saying, the accused dealt a tabli blow to my head. As a result, I sustained bleeding injury. My daughter Rajeshwari came and protested, my lord. On the initial stage, my lord, what I am giving a pause, my lord. Initially, the injured people 19 were there and the deceased were not there, my lord. When he assaulted the deceased, the wife, my lord, when he assaulted the injured people 19, deceased came into rescue of her mother, my lord. But it is my lord, very important, my lord, as because the no intention to commit the murder of the wife, my lord.
No, then you don't stop. You don't go on chopping. First you chop her hand, then you chop her face, then you chop her head.
That is latter part, my lord. As a result, I sustained bleeding injury. My daughter Rajeshwari came and protested.
The problem is when you start reading one line, I'm already reading the fifth.
I left hand, my means of tabili causing bleeding injury. Accused also did another blow to her head and to her face. My daughter Rajeshwari fell down on the ground. Accused also dealt 2 other blows to my head. I fell down and became senseless. I can identify the tabili in which blows was given to us. MO1 is the said tabili. I regained my sense at a Burla hospital after 4 days after the occurrence, my lord. But the I was stated, my lord, he has examined on 26th, my lord. Cross-mention. We have filed a divorce case against the accused.
What are her injuries? Can we know?
My lord, injuries, my lord.
Because
Dr. PW 18, my lord.
We'll just go there and come back here, sir.
My lord.
Anantara Meher. 7 injuries, sir.
My lord, 7 injuries, my lord. But
that is disease.
My lord,
what about the mother-in-law?
My lord.
What about Kuni Mishra?
Kuni, my lord, survived, my lord.
No. Where are her injuries?
Injuries, my lord.
PW 21, Manorama Satpati.
My lord.
Let's read that. My God.
There are, my lord, 3.
I got. You're lucky that your mother-in-law survived.
What is the intention to commit the?
Only you wanted to murder the mother-in-law.
No, wanted to murder, assault, my lord, not commit murder, my lord.
Just
because
let's see what is that. Just read the injuries.
One
brain.
fracture. 3 injuries, my lord. But
no, read the injuries, Mr. Agada.
1 inside wound, 4 inch into to a brain depth, fracturing the.
My goodness. So it's brain depth,
my lord,
which means it has gone through the skull. It's fractured the skull.
But however, my lord, she survived.
That's a miracle. That's a miracle.
My lord, 5 years commission there, my lord. But so far, my lord, the.
You are so seasoned, you're not reading the other injuries now.
My lord, PW 18, my lord, in cross-examination, doctor, my lord, who examined the disease, my lord.
Yes.
Injury number 1, 2, independently may not cause death of a person, but injury number 3 can cause the death, my lord. And only one injury cause the death, my lord. My whole case rests on the evidence of the my lord PW 18, my lord, and also PW 1. If my lord 7 years, lordship, part 2, lordship.
No. Part 2. What are you saying? Your client specializes only on the head injuries.
There are 7 injuries.
Never. For him, no other part of the body is attractive. Only the head.
Whatever he done, my lord, out of anger, my lord.
Whether mother-in-law or wife, everybody has to be attacked on the head.
Since my his mother and sister has been arrested in another case, my lord, for that reason he committed the crime, my lord. And only intention to assault, not to commit murder, my lord. My lord, interestingly, my lord, though the tablet in question, my lord, that have been seized from the house of one Surabhai Tripathi, my lord. He has not been examined, my lord. And the IO admitted, PW 22 admitted in cross-examination that I examined Surabhai Tripathi, who denied his knowledge about concealment of tabli on the roof of his house, my lord.
All right.
These are the, your lordship is part 1 or part 2?
Not a good case, Mr. Ragala.
I know, my lord, there is no question, no good case, my lord. Since, my lord, the 7 years in imprisonment, your lordship, that part of technical.
No. So we'll pass the judgment. Dismissed. I'll dictate the detailed judgment. We'll give you. All right. Dismissed.
I verified. I verified the 161 statement of that PW3. She has stated.
No, you put it in your note. Because the other side is also to be there. He's not here. He's not here, Mr. Zafrullah. You have to. Any argument is in presence of other side. So you pull it. You give us in your written note. You can give a translated version and to copy it to the other side.
Can I take the 161 statement of that?
Yeah, you can. Actually, after the case is over, after we rise, you can take it from him and note down.
May I please? Here is the appellant is convicted on 302 and 307. And the date of occurrence is 31/8/2002. And now 2020, almost 20 years in the custody.
He's still in custody?
Yes, madam.
Oh.
And he has written the letter. That's why I am.
How many people died, sir?
Double murder case.
Double murder.
That is why.
That is why. All right. Karpura Gowda.
And I have gone through the entire evidence and find that 2, 4, and 6 all are the eyewitnesses.
Eyewitnesses. All right. So let's read them, sir.
One thing is that in the 31/8/2002, the morning, the appellant came and assaulted one PW1. First, he was injured and he escaped from then he went to the house of the informant and assaulted his son. Then he came to the village Dando and assaulted the other. And what is the motive behind that was not
uncontrolled rage, basically. Let's see that. Yeah. PW2, we'll start.
Yes, madam. Page 51. I am an Adivasi lady and an illiterate. I know Kapura Gowda, the accused, now standing in the dock. I also know Purna Gowda and Khabapati Gowda, PW1. I also know Rabi and Subhash, the 2 sons of Purna, during their lifetime, who are now the deceased of this case. About 1 year and 7 months back, in the morning near our colony, this occurrence took place. I was bringing water from the boring and along with me, Sonia Goudoni was also there. I saw at this time the accused Kapura Gowda is rushing with a tangia in his hand after Subhash, the son of Purna, and immediately the accused gave 3 assaults in his axe on Subhash, which fell on his neck and face. And seeing this assault out of fear, I immediately rushed from the spot. Due to the assault, Subhash fell down on the ground. I shouted the assault was given to Purna Gowda's son by Kapura. Later on, I heard that accused Kapura Gowda also assaulted the other son of Purna Gowda in his house, causing his murder. The seized axe was shown to the witness for her identification, and she identified M1 is the said axe which was the accuser holding, then and with which he gave an assault to Subhash. All
Cross.
then
No, cross. You don't want to
yes,
read the cross.
yes, ma'am.
Ah.
I cannot say to whom this axe belongs to it. It is a fact that today I saw this axe in the court for the first time after seeing it on the day of occurrence in the hand of accused Kapura Gowda. It is a fact that boring from where I was bringing water then was lying by the side of the road leading from Jaipur to Nabrangpur. It is a fact that at the time I was pressing the handle of the boring in order to get water, houses of Harijani and Kamya Amantarai are situated near the boring. The distance between the boring and the place where assault was given on Subhash is about 100 yards. From the well, the scene on the side road is clearly visible. I had not seen any other villagers present there at that time. I have been working Kapura since my childhood because I am a co-villager. He has no enmity or dispute with any villager to my knowledge. He had also no enmity against Punna Gowda. It is not a fact that at the time of assault, I had not shouted and that I have not at all seen this assault occurrence. Today, for the first time, I am deposing regarding the occurrence before the court. It is not a fact that now I am deposing full falsehood on the instigation of our villagers.
Nothing. You've got nothing from this witness.
Yes.
Solid witness. Strong lady, clearly. Then PW4.
PW4. May I read? I am an illiterate and Adivasi. I know accused and deceased of this case. In the early morning, I was coming out of my house to the road. I saw accused Kapura Gowda coming with an axe in his hand. At the time, Subhash, the eldest son of Punna, was coming by that way, and accused Kapura assaulted him with that axe, 3 to 4 assaults on his neck, face, and head. As a result, Subhash fell down on the ground, sustaining bleeding injury. Accused went away with the axe in his hand. I shouted to Punna that accused assaulted his son, and Punna came to the injured son. The seized axe was shown to the witness. MO1 is the said axe.
So first Subhash dies and then Ravi dies in the Danda.
And all the evidence against the all the evidences are seen by this son first Ravi. Others that he has assaulted and came to this Danda and assaulted this boy.
No,
nobody has seen
who was assaulted first, Ravi or Subhash?
His elder son. Subhash. So Ravi was assaulted first. Subhash second. Ravi was assaulted in the house of the informant.
What you didn't tell us, Subhash is just 5 years old. Ravi was 8 years old.
Yes, my lord.
Two very young boys. My goodness.
That is
Madhava Parija. That's what you're reading, right?
Yes.
You're reading Madhavan.
Yes.
No, but who saw the assault on Ravi?
Nobody has seen.
Achha, but Ravi is killed.
Killed.
No. When he comes in the front of the house of Ganesh Bisoy and Nilakanta Anantaya, Nilakanta and others who were present there told me that Karpura was assaulting my son. No. Rabi is seen by Sonai. Come to PW6.
Yes.
PW6 is the eyewitness for Rabi.
Wrong. Robbie, this Subhas, he has told that Robbie.
No, PW6, Sonai.
Yes, my lord.
She has spoken about Rabi being assaulted. They have solid witnesses, sir. Nothing has been elicited in cross-examination. Nothing at all.
The petitioner has already
Served
20 years in custody.
That,
and
depending on the remission
and
policy,
your lordship
double
can
murder,
direct
sir.
for remission of the, I have the judgments.
All right, but double murder.
Four judgments. Where the 11.
One boy is 8 years, one boy is 5 years.
11 persons has killed by the petitioner appellant and he was released for to him by this 2020 SCC online Supreme Court 6 to
Sure
6.
versus State of Uttar Pradesh. No, death sentence must have been commuted.
No, my lord. That was the conviction and another second.
No, that must have been a writ petition. That is something else, please. It's not pursuant to criminal appeal.
Then challenge the after.
No, that is because of the policy of remissions.
Yes. And second one is the 2007-13 Supreme Court, where the appellant has killed his own daughter, and why she has killed.
So
his
again,
daughter.
they are deciding about clemency of the executive.
No, say that 2017 he has not claimed. The Honorable Supreme Court has sent the why he has killed. That trial court has not elicited.
No, all that is for death sentence, sir.
The second one is the 2007-13 SCC 449.
I think the accused was a woman. Yeah. Kokaya Bai.
Yes, ma'am.
Woman killing her own daughter. That's very different. It's very different.
There is no motive.
Anyway, we'll examine all this.
Yes, ma'am.
Appeal is dismissed. Pass this. This one.
Give apology, sir. In item 2, I have requested.
Yeah, we've dismissed it.
Plus that I have given a note of
order.
I have already handed over.
Order.
Then
Order. No problem.
I'm very sorry I could not appeal.
No problem.
But in item 3, only your lordship can have a glance to the injury. How he has mercilessly assaulted both the child. In that case, yes.
Why
all are inside one and
it was not elicited why he has killed that two innocent boys.
Sir, you know, eyewitness, direct evidence, motive is not issue.
Are there.
Yeah.
But
small
in the morning, why there is no enmity, nothing has been.
No, he goes and chases. The point is the two different places he's killing them.
Might be there is some mental.
There must be something.
Item number 4.
Oh, my lord, in this matter, my lord, Mrs. Saswata Patnaik was engaged by the petitioner, my lord, to conduct this matter, my lord. Now, Mrs. Saswata Patnaik is a government advocate, my lord. So we have to take instruction whether she will conduct some.
Whom are you there for, sir?
My lord.
Whom are you appearing for? Whom are you appearing for? The appellant?
My lord.
You have a wakalat?
My lord.
Then why did you argue?
Paperwork are not ready with me.
Why? This matter has been shown in the list for a long time.
My lord.
Where is the paper book you collected right now? Just take out the paper, give it to him right away. There must be extra copy, no? Give him one copy straight away. You get ready, it will be on board. Next Thursday, it will be taken up.
My lord.
उनको दे देना.
On board.
It will stay on board.
Weekly list item number 5. Weekly list item number 5.
Madam, you are waiting for which case?
I'm for item number 7, Milord.
I see.
Sir.
All right. No problem.
Item 6, my lord.
Tell us.
There are connected cases, my lord.
Mr.
Ponda is there, my lord.
All right. Amjad Khan. He's still not back. Mr. Panda is
Your
here.
Lordship, I'm appearing on VC on behalf of Mr. Panda, Your Lordship.
What happened?
Your Lordship, the paper books are not available. We even checked at the office, but it's not available. So can a direction
1
be
minute.
passed?
Let's just open file of 6. 1 minute, madam. How many paper books are there? To make photocopies and give them. Do we have for ourselves? No, for the judges is the paper book there. Both of us. I think make a photocopy, 2 photocopies. You have a paper book.
I have paper.
So we'll just make 1 photocopy and give it to Mr. Panda. It will stay on board. Next week we'll take it.
Your Lordship, next week is a little difficult for Mr. Panda. Can we shift it the next to next week?
Next week also, next Thursday is a holiday. So next week means it will go 2 weeks later.
Yes, Your
It
Lordship.
will now come up only on 21st.
All right, Your Lordship.
May I also make a prayer, my lord? There are 2 criminal appeals, my lord. The second criminal appeal or copy of the paper will also be supplied to the state, my lord.
21st. Yeah, 21st. Actually, next week is 7th. So week after. It will come on 21st. Right. All right. You just say paper book of this case. That is paper book in Criminal Appeal 293 of 2006. Be provided to counsel for the appellant. Call on 21st. Right. Both matters.
Weekly list item number 7.
Pleasure.
May I please your sirs. I'll first, it is my first placement before sirs. I am very much thankful to the giving permission to the bar to address the bench with sir.
All right.
Making a distance less between bar and bench.
That's right.
I am
That's
obliged.
right. Okay.
It is a matter of 2005, Milord. Sir. And it is, I will, before coming to the facts of this situation, I will make a request to your good self to have a visualize the situation. Like it is the month of January. January 20, 2005. 17 years back. The area was in interior, I mean a forest area, where the person was coming by a cycle. It is morning about 10:15 a.m. Coming by a cycle. The deceased was sitting on her house by returning from her parents on the veranda of his house, and her husband was taking food inside the house. And PW4 is sitting beside that veranda making a rope by sabaigas, one type of grass, using ropes. When the person is coming, with one single sentence abused word he used, and putting his cycle on stand, come to the person sitting on the veranda, and then the person making the rope, he was protested, don't say like this and go to your home. And he come to that cow shed, brought that spade and put a stroke or blow on the back of the deceased. The situation says that killing a person or making assault a person, it is not an easy task. there must be a quarrel. There must be something previously. No evidence there. They have any previous quarrel, anything. By none of the evidences, PWs, DWs, no one. And he morning hour is a cool hour. And there is no cause why he will come and assault the person, saying that, sister-in-law, I will kill you. That is quite not acceptable.
Survive or she dies on the spot?
Pardon?
Does she survive or she dies on the spot?
I'm coming to the matter, Miller. When he was assaulted, the person was sitting on the veranda nearby her. He did not try to protest him. Only when he find that he keeping the cycle there, coming to the cow shed.
How does he know what he's going to do?
Now he went and come with the spade. At that I should come and protest him.
Everybody is not hero. Film hero only will do all that.
Yes, sir.
Ordinary people will get scared.
He made a blow on the backside of the deceased. Question arose, in the forest areas, houses are very small, thatched houses, and the veranda is also 1 feet or like that broad. And when the person is sitting, he must have been making his face towards outside, not to the wall. And how could he put his hit or blow on the backside of the person? There cannot be a stress or strength on that blow that will be injured. Then the informant says that on the first blow, he fell down. And there was a swelling only. No bleeding injuries, he says. And only fell down and senseless. Leaving her in that condition to senseless. The persons, the husband eating inside the house and the brother-in-law sitting making a rope, they come to arrange money. No one stated that they were put water on her, give her water drinking or give any food. He expired after 30th. Going to the hospital, then they went to his father-in-law's house, arrange money and come to the person and take him to the Baripada hospital headquarters. By that time, she was without water, without food.
You're not telling us the sequential facts. 10:15 in the morning on which date?
28th of January.
And she died on 30th.
Yes, Milord.
You take us to the postmortem immediately. Take us to the postmortem report.
But in
or the doctor's evidence. Let us see the doctor's evidence.
PW7, page 55 of the paper. PW7 plus page 55 of the paper.
On 31st of January 2005, I had a specialist in the skin and BD district headquarters hospital.
3 injuries, miss.
Pardon?
There are 3 injuries, one lacerated wound, one hematoma size.
Yes, Milord, but question arose. If the person was with a only single blow and the informant says
single blow, madam, 1 minute, page 55. Let's
only
read
single blow, sir.
Let's read it. No problem in reading it. No? On 31st January, read the whole thing. On 31st January.
On 31st January 2005, I was the specialist in skin and BD district headquarters hospital, Baripada. On that day at 11:15 p.m., police requisition, I conducted post-mortem examination over the dead body of Makuri Naik, wife of Harihan Naik, at village Bodarai PS Khinta, district Mayurbhanj. Being identified by the police constable number 510 SK Mohapatra and others, and found the following external injuries. One lacerated wound.
Lacerated wound.
Sir?
Lacerated wound.
Lacerated, it is letters are only not properly visible. Found at size 1 cm into 1 cm on right occiput thermoporal region. One hematoma of size 3 on into 3 cm below the right occipital temporal region. Fracture of skull of 1
So,
into
madam, all three injuries are on the head, not on the back. You gave a whole description of how he assaulted her on the back.
Sir.
All injuries are on the head.
Sir.
There is fracture of the skull.
Sir.
So you have to completely now re-understand the way the occurrence happened. The man went straight for the head. And he did not stop with one, he gave 3 blows.
Only 1 blow, sir. See, it is specifically stated by the informant that is only 1 blow.
Informant is not the point, madam. Medical evidence is where you start knowing how many injuries are in a person.
Sir, that injuries may be caused by some other thing. But
we'll see. Which other thing can cause fracture of the skull, we'll examine.
He fell down from the veranda to the ground.
And fractures. Because she fell down, she got fracture of the skull. Skull is the strongest part of the head, madam.
Sir, my point of placement is submission before your good self is that it is she is dead. It is, I'm sorry for that. She is injured. She was attacked, but not by the appellant.
We'll come to all that. We're right now only understanding her injuries. Okay, we'll come to who did that. Just read on. The injuries were ante-mortem.
The injuries were ante-mortem in nature and was sufficient in
ordinary course
of nature to cause death. Time since death within 24 hours at the time of my post-mortem examination. The injuries were probably caused by a hard and blunt object. This is the post-mortem examination report presented and submitted by the marked as me and marked as Exhibit 4. Within this, it is my signature as Exhibit 4/1. On 1405 police requisition, I examined and examined one spade sent to me for examination by the OIC Khunta PS. On examining the spade, I opened that the injuries mentioned in the post-mortem examination report Exhibit 4 were possible with the blunt side of that spade. This is that spade MO1 examined by me. This is my report, Exhibit 5 on examination of the spade, wherein this is my signature, Exhibit 5/1. Cross-examination in by SDC. Such injuries cannot be caused by fall on hard and blunt or stony surface. Police had not sent the spade MO1 to me for my examination on 31st January 2005. It is not a fact that I had not conducted post-mortem examination properly and have submitted the report Exhibit 4 at the instance of the informant and others. Type to my re-examination.
So at least one of your doubts is cleared.
No, Millard, my doubt is not clear. It is still there. She is dead. She is injured. It is sorry state of affair. Me being a woman, I should be more careful for that.
No.
Appellant is.
You are only a lawyer. You are not a woman, man. You are a lawyer.
First a woman, then a lawyer, sir. So that appellant is not the. Now he is 17 years behind the back. I will going through the documents. I'll prove the citations and I will establish that he is not the killer. By such a coming a person in a cool hour can never come and kill a person, and only one stroke is there, only one swelling is there, and all the other things I am coming
one
to.
One swelling, one fracture, one lacerated wound.
Millard, sir, I am telling that all these things maybe if we will go to the other side. My thinking behind my subconscious mind is that thing is caused by these husband and husband's brother, maybe. And that person is caught by supposedly caused and he is not no way connected. Simply he was denied. I don't know anything. If he could cause the death, he could have been run away from that place. He could not. He just he told that he was throw the spade there and take his cycle and coolly went away. How is that? After causing the death, causing the incident, those persons might have come and cut him out. But no hand on that.
Yes.
They stated that he is put the spade there and take his cycle and coolly go away.
All
How
right.
can possible? When in my front,
Which eyewitness you want to read first?
that exhibit 1, the informant told that he has put it.
No, which eyewitness you want to read first? Let us start reading.
That is in Oriya Milla, that the informant himself herself.
PW5 with eyewitness. PW5 49, page 49.
No, let her read whichever she wants. Accused is the brother-in-law, but this is related.
Deposition witness number 5. I know the accused standing on the deck, PW4, is my brother. The deceased Makari was the wife of PW4. After 12 to 14 days of the last Makari
festival.
Makar festival. Sorry. As the name was similar, I thought that there may be Makari. That Makar festival at about 10 a.m. While I was on the veranda of my house and PW1 was preparing sabai rope on the veranda near me, the deceased came from Baripada and sat on that veranda. After 5 minutes, the accused came there and on a cycle and abused the deceased. I protested. What she told, she was told only one sentence.
No, let's read on.
Yes.
I protested and told
I protested and told the accused not to shout in our house. Thereafter, the accused brought a spade which was lying near our cow shed and assaulted on the
backside of the head. No wonder you're stopping with back. There is one line below that. You do not read it.
Backside of the
head
of the deceased with the
blunt side of the spade.
As a result of which the deceased fell down, sustaining bleeding injury. Millard, it is stated that bleeding injury. It is the informant told, as he was also witness, that there was no bleeding injury, only one swelling. I will come to that. On her head. At the time of the offense, PW4 was taking his meal inside our house. It is also one thing to be noted, Miller, Mr. That when the shouting is going outside, there was an assault, someone is fell down, and how the person was sitting inside and taking food till then.
All this happens in a matter of seconds, madam. It's not slow motion, like you're seeing in cricket match, action replay.
Cow shed is always at a little distance from the house.
Correct. One before people knew what is happening, the man has got a spade and he's hit her thrice.
Sir, I do understand. If there is a quarrel, there is a heat of passion, a person will run in that way. But here is very cool, nothing wrong.
No, we don't know about how cool. You'll read. We'll see how cool he was.
Sir, in the map, there is no case of the cow shed where it is there.
All right. Read on.
His meal inside our house. After sustaining the assaulting the deceased with the spade, the accused threw the spade near the spot and went away by his cycle. On the next day, we took the deceased to the district hospital. On the next day, what they did with the injured person till then, nothing about that. Hospital. Baripada for her treatment. On the next day, that is on Sunday, the deceased died in the hospital while undergoing treatment. I can identify the spade with which the accused had assaulted the deceased. This is the spade, M1. Here, what happened, Millard?
No, you read, please. Your anything in your support will come only in the cross-examination.
Cross-examinations by SDC. The occurrence took place on the veranda of my house. I had seen the occurrence as I was on that veranda. I was at the distance of 10 to 15 feet from the deceased at the time of the occurrence. I had never seen PW4 taking with the
talking
with the accused The accused used to visit our house occasionally. Vaikuntha Naik is the first husband of the deceased. The accused is the Sadhu, brother of husband of his wife of the first person we called in Odia Sadhu. Sadhu of Vaikuntha Naik at my village. Vaikuntha had not come to the spot after the occurrence. We had not told him about the occurrence. It is not a fact that there was no such occurrence. One due to
and
due to the injury inquiry.
No, between PW4 and the accused.
Because between 4 and the accused, we have created this case with false allegations, and I was deposing lie. Yes, Milord. This I am coming to the informants. What she has stated in her informant. Unfortunately, this is in Odia and it has not been translated in English.
Which one?
That informants FIR, which
No, you would have confronted the evidence is in deposition is in English. You would have confronted that PW1 if there is contradiction in the FIR.
So many things, sir. I will prove that the appellant is not a killer.
Sure. We want you to do that, but we'll have to be convinced.
Here it is in Odia. If I will go through this in Odia and second time I will place in English.
No, let us read the deposition. Then you can, because in the deposition you would have confronted the witness with what is stated in the FIR.
Yes, here it is.
So let us read the deposition first.
She is telling that there was only a swelling.
Let us read it, madam.
Yes.
I know the accused standing in the dock.
Question, sir?
Page 37, paper book.
I know the accused standing in the dock. I am the informant. The accused Makari Naik was the wife of...
No, deceased Makari.
Deceased. Sorry. Deceased Makari Naik was the wife of my nephew, Harihar Naik. The accused is the brother-in-law of the deceased, being the husband of her elder sister. Last year, few days after the Makar Sankranti, the occurrence take place in the house of Harihar Naik in village Bodaraikali. The mother of Harihar Naik is my elder sister. I was in the house of Harihar Naik by the time of the occurrence. On the day of occurrence, that is on a Friday, at about 10 a.m., while I was preparing Sabai rope on the veranda of the house of Harihar Naik, and the deceased was sitting near me. After returning from her father's house, the accused came there on a cycle from village Tulasi Mani and assaulted on the backside of the head of the deceased Makari Naik with a spade, saying that slang that sister-in-law, I will kill you. The accused assaulted the deceased with the backside of the spade. due to the assault, the deceased received a bleeding injury. Here in English statements, he stated that it is bleeding injury, but in Oriya version, it is not there that was any bleeding injury, only a swelling. That is spared due to the assault, the deceased received a bleeding injury on her head and fell down. The deceased had brought the spade from the cowshed at my nephew's Harihar Naik. After assaulting the deceased with the spade, the accused ran away, throwing the spade near the spot. The house of the deceased was taking. The husband of the deceased was taking meal in his house by the time of the assault. My elder sister, Bilash Rebati Naik, wife of Chandra Mohan Naik, and Basanta Naik were present near the spot at the time of occurrence. So many people are there, Miller, sir, but no one has taken any prevention step to save the wife deceased. On the following day, the deceased was taken to the district headquarters hospital. On the next day, she was taken, but no treatment was made, no food, no drink was given to her by that time. And she is dead with injury, with fasting and starving and with need of water. Baripada for his treatment, her treatment. She died in the hospital on the next day at about 12 noon while undergoing treatment. I came to know about the death of the deceased about 4 p.m. On that day, when her husband Harihar Naik returned to the house and told me about the death of the deceased. Thereafter, I, along with some gentlemen of the village, went to the Khunta PS. A teacher whose surname was Mahapatra scribed the report as per my instructions. He read over and explained the content of the report. I put my LTI thereon and then submitted the same before the OIC Khunta PS. Police came to the spot in the night of that day, and on my production seized the weapon of offense, that is one spade, before the witnesses and prepared seizure list. I can identify the spade if the same is shown to me. This is the spade, MO1. Cross-examination by STC. I am a resident of village Kondalia, which is about 10 to 15 kilometers away from village Bada Raikali. I used to visit the house of my eldest sister, that is the mother of the Harihar Naik, frequently. Chandra Mohan Naik and Harihar Naik are the two sons of my elder sister. Chandra Mohan had married to marriage in village Sundaria. His father is dead. Mokari Naik is the deceased had first married to Boykuntha Naik at village Bodaraikali. She has one son born through her first husband. Subsequently, she married Harihar. She has a daughter born through her second husband. Harihar Naik, prior to the accused occurrence, the deceased along with her daughter were residing with at Baripada in the house of her husband Harihar Naik. Harihar Naik was residing in village Badaraikali by that time. I know the accused prior to the occurrence. He is a resident of village Belpal. I cannot say the date of the occurrence. I cannot exactly say from which place the deceased had returned to the house of Harihar Naik by the time of the occurrence. I cannot say the cause of the occurrence. This since the scribe had not read over and explained the content of the report to me. After he wrote the report, I put my LTI therein and then gave the same to the police in Khunta PS. I do not know the name of the gentleman of the village who had gone with me to Khunta PS. Bilas, Reboti and Chandra Mohan were in the house of the Harihar at the time of the occurrence. None of the villagers came to the spot at the time of occurrence. I had told the occurrence to the scribe in village Bodaraikali. I was not examined by the police in this case. I had not gone with the deceased to district headquarter hospital when the deceased was taken there for her treatment. It is not the fact that the accused had not gone to the house of deceased at the day of the occurrence and that there was no such occurrence and that the wife of the accused is not the elder sister of the deceased and that I am deposing life.
Nothing elicited from the witness.
Sir,
nothing has been elicited from this witness in cross-examination. Nothing to favor you.
Sir, I may be permitted to another one. I'll place the dead chart, the note of argument, and the citations before your good self, so that I can release my client. In other words, sir, the person he has already been there for 17 years, and that for no fault on his part. It is not that as I am the lawyer, I should save my client. If his client is really done the crime, he should punish. It is my privilege that he should. But I am sure that I can make him release. Obviously.
So, when will you submit your note, date chart and all? Next Thursday, 7th.
7th. No, sir. Please, more time is required because I have to go outside for 4 or 5 days.
No, your client is in jail. You can't go out.
Sir.
Till you finish the case, you cannot. 17 years is a long time. So you first finish all this, then go out. And then come back for 7th. 7th April. We'll continue on 7th. You prepare all that. All right.
Yes, sir.
We'll rise now. 7th April, madam.